And if earlier listed, then just you also give the date. I mean, already directed to be listed on certain dates, so please mention it. Then the file can be traced.
Wiki list, page 1, 2 and 3.
The mediation chadun to पढ़ू ना page 1 and 2, 3 to 11.
Look, item 5
5.
may be permitted to withdraw and filing.
Yes. Tarkota memo ta rakho. It will be dictated. You are present. It will be dictated when the matter reaches. Any earlier orders are there?
No. It's fresh.
Yes. Next, please.
Page 3, 14 to 19.
Up to 11 then. Up to 13, 12, 13 orders. Orders will mention. Then 3. Madam, why were you?
Item 24 sir, case withdraw kare
Item 24 case withdraw kare pe chahun. ଆପଣଙ୍କର ନିଜେ କରୁଛନ୍ତି ନା ଓକିଲ ଦେଇଛନ୍ତି? 24 କେସ୍ ଆପଣ ନିଜେ କରୁଛନ୍ତି? ଆପଣ କଣ ଲର ଛାତ୍ରୀ? ଆଇନର ଛାତ୍ରୀ ଆପଣ? ଆଇନ ପଢିଛନ୍ତି? ତ ସେଥିପାଇଁ କୋର୍ଟରେ ଯେତେବେଳେ ଆସିବେ ଭାବିଛନ୍ତି ଆପଣ 24 ରେ ଆପଣଙ୍କ ନାଁ କଣ କହୁଛନ୍ତି? ସେଇଟା ଆପଣ ନିଜେ କରୁନାହାନ୍ତି, ଆପଣଙ୍କର ଓକିଲ ଦେଇଛନ୍ତି। ଆପଣ ଯାହାକୁ ଯେତେବେଳେ ଦେବେ କେସଟା, ଆପଣଙ୍କର ମାମଲା ଯାହାକୁ ଦେବେ ତାକୁ ଗୋଟେ ଅଥରାଇଜେସନ ଦଉଛନ୍ତି। ତେଣୁ ଗୋଟେ ଜିନିଷରେ 2 ଜଣ କହିପାରିବେନି, ବୁଝିପାରୁଛନ୍ତି? ଆପଣ ଯଦି ତାଙ୍କଠୁ କଣ ଆଣିଛନ୍ତି ଓକିଲତନାମା? କୋଅପରେଟ ନ କଲେ ଓକିଲ କେସ୍ ୱିଥଡ୍ର ହେଇଯିବ, ସେମିତି କୌଣସି ଆଇନରେ ପ୍ରୋଭିଜନ ନାହିଁ, ବୁଝିପାରୁଛନ୍ତି? ଜଜର ସେଥିରେ ଜଜ କରିପାରିବେନି, ଜଜ ଗୋଟେ ଅର୍ଡର ପାସ୍ କରିପାରିବେନି ଯେ ଓକିଲ କୋଅପରେଟ କରୁନାହାନ୍ତି କେସ୍ ୱିଥଡ୍ର, କାହିଁକିନା ଜଜଙ୍କର କାମ ହେଲା ସେ ବିଚାର କରିବେ। ନିଶ୍ଚିତ ଭାବରେ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଠିକ କଥା, ଯେ ଓକିଲ ଆସିଷ୍ଟ କରିବେ ବା ଓକିଲ ଜଜକୁ ପଢେଇବେ। ଆମର ସିଷ୍ଟମ ହଉଛି ଓକିଲ ଜଜକୁ ପଢେଇବେ। ଆପଣ ଯଦି ୱିଥଡ୍ର କରିବେ ଭବିଷ୍ୟତରେ କେସ୍, ତେଣୁ ଆପଣ ଓକିଲଙ୍କ ପାଖକୁ ଯିବେ, ଗୋଟେ ଓକିଲତନାମା ତାଙ୍କଠୁ ଲେଖେଇକି ନେଇ ଆସିବେ ଯେ ଶୁଭୁନି, ପାଖକୁ ଆସ, ଶୁଭୁନି ନାଇଁ, ମୋବାଇଲ ନୁହଁ, ମୋବାଇଲରେ ଓକିଲତନାମା ଦେଇ ହବ। ଆପଣ ଯୋଉ ତାଙ୍କ ମୋବାଇଲରେ କଣ ଦେଖା କରି କେସ୍ ଦେଇଥିଲେ?
ନାଇଁ ସାର୍, ମୁଁ ମାନେ ମୋର ଗାର୍ଡିଆନଙ୍କ ମାଧ୍ୟମରେ ଦେଇଥିଲି।
ସେ ଗାର୍ଡିଆନକୁ କହିବେ ଯାହା ମାଧ୍ୟମରେ ଦେଇଥିଲେ। ଆମେ ସମୟର ଅପଚୟ କରୁଛେ ବର୍ତ୍ତମାନ। ଏଇ ଜିନିଷଟା ଏ କୋର୍ଟରେ ଆଲୋଚନା ହବା କଥା ନୁହଁ, ଯେହେତୁ ଆପଣ ଜାଣିନାହାନ୍ତି ତେଣୁ ମୁଁ ସମୟ ଅପଚୟ କରୁଛି। କିନ୍ତୁ ଏଇଟା ଗୋଟେ ଆଉ ଗୋଟେ ଅସୁବିଧା ହଉଛି ଯେ ଯୋଉଟା ଆପଣଙ୍କୁ ମୁଁ କହିଲି, ଆପଣ ତ କିଛି ଜାଣିନାହାନ୍ତି କହିବେ ମୁଁ ତ ସେମିତି କରିପାରିବିନି। ଆପଣ ଯୋଉ ଗାର୍ଡିଆନଙ୍କ ଥ୍ରୁରେ ଯାଇଥିଲେ ତାଙ୍କୁ ନେଇକି ଓକିଲଙ୍କ ପାଖକୁ ଯାଇକି ଆପଣଙ୍କର ଯୋଉ ମାନେ କେସଟା ନେଇକି ଆସିବେ ଗୋଟେ ଲିଖିତ, ତାପରେ ମେନସନ କରିବେ। ଯେତେବେଳେ କେସ୍ ଯାଇଥିଲେ ମୋବାଇଲରେ ଦେଇଥିଲେ କେସ୍? ତେଣୁ ଆପଣ ସେଇଟା ଆପଣ ସେମିତି ଏଠି ବିତଣ୍ଡା ବା ଅଯୌକ୍ତିକ କଥା କହିବେ ନାହିଁ କୋର୍ଟରେ। ଆପଣଙ୍କୁ କୁହାଗଲା ଯେ ତାଙ୍କ ପାଖକୁ ଯିବେ, ମୋବାଇଲ ସୁଇଚ ଅଫ୍ ଆପଣ 4 ଥର କହିଲେଣି। ଆପଣ କଣ ଲାଗୁଛି ଯେ ଜଣେ ଜଜ ବୁଝିପାରୁନି ଯେ 4 ଥର ମୋବାଇଲ ସୁଇଚ ଅଫ୍ କହିଲେ? ମୋବାଇଲ କଥା ଆପଣଙ୍କୁ ପଚରା ହଉନି, ବୁଝିପାରିଲେ? ଆପଣ ଓକିଲଙ୍କଠୁ ଆଣିବେ, ଆପଣ ଯୋଉଟା ଚାହୁଁଛନ୍ତି ସେଟା ଆସିକି କୋର୍ଟରେ ସେଟା କହିଲା ପୂର୍ବରୁ ଓକିଲଙ୍କଠୁ ତାଙ୍କର ଗୋଟେ କାଗଜ ନେଇକି ଆସିବେ ଯେ ମୁଁ ଏଠାରେ ଆପିୟର କରୁନାହିଁ, ବୁଝିପାରୁଛନ୍ତି? ଯଦି ଆପଣ ଆଣିବେନି ଅସୁବିଧା କଣ ହବ? ଆପଣ ପାଠ ପଢିଛନ୍ତି କୋଉ ଯାଏ? ଗ୍ରାଜୁଏଟ। ବୁଝିପାରୁନାହାନ୍ତି ପ୍ରଶ୍ନ? ଆପଣ ଯାହା ପଚାରିଲେ କହୁଛନ୍ତି ମୋବାଇଲ ଉଠଉନାହାନ୍ତି। ସବୁ ପ୍ରଶ୍ନର ଉତ୍ତର କେବେ ମୋବାଇଲ ଉଠଉନି ହବନି। ଆପଣଙ୍କ ନାଁ କଣ? ଆପଣ ମୋବାଇଲ ଉଠଉଥିବେ ଯଦି କହିବେ ମୋବାଇଲ ଉଠଉନାହାନ୍ତି, ତାର ଉତ୍ତର ଦେବେ। ଆପଣ ଯଦି କେସ୍ କରିବାକୁ ଚାହୁଁନାହାନ୍ତି ତାର ଗୋଟେ ଆଇନରେ ଗୋଟେ ଅଛି, ପଦ୍ଧତି ଅଛି। ସେଇ ଜିନିଷଟା ଏଠି ମୁଁ ନାହିଁ ଯେ ଯିଏ ଆସିବ ତାଙ୍କ କଥା ଶୁଣିକି ତାକୁ ସମୟ ଦେବି, ଯେମିତି ଏତେ ଆପଣଙ୍କର ଆପଣ ମାନେ ବର୍ତ୍ତମାନ ଯୋଉ ଓକିଲଙ୍କୁ ମାନେ ପାଇଁ ଆପଣ ସନ୍ତୁଷ୍ଟ ନୁହନ୍ତି, ଅସନ୍ତୁଷ୍ଟ ଅଛନ୍ତି, ମୋବାଇଲ ଧରୁନାହାନ୍ତି ବୋଲି ଗୋଟେ କାରଣ ହେଇପାରେ, କହିପାରିବିନି। ସେଟା ଗୋଟେ ଯୁକ୍ତିଯୁକ୍ତ କାରଣ ନୁହଁ, ସମ୍ପୂର୍ଣ୍ଣ ଅଯୌକ୍ତିକ। ଓକିଲ ମୋବାଇଲ ଉଠେଇବା ପାଇଁ ତାଙ୍କର ଇଏ ନୁହଁ। सेटा भी आपण बुझिया दरकार आउर समय तो नष्ट करे ना आउर समय नष्ट करे प्राय 15-20 वर्ष तळे माने वकिलाती करथिली बंद कर
In this matter, we have been interested yesterday. We have been काली ही हमको नहीं सर काली ही हमको इंटरेस्ट ही चाहिए लॉर्डशिप मैटर टा आई एम फाइलिंग में वकालतनामा
पढिला बेले कहबे ना कोन आसी एडवांस कहबे इंटरेस्टमेंट आपण केते बेले कहबे केस पढिलो ऑर्डरमेंट पर एडजमेंट केबे भी नथिला ऑर्डरमेंट ऑर्डर हैज टू बी पास्ड बी पेशेंट लेट जस्ट गिव हिम अ चांस से कोन खोजो तांगर ट्रेड सुनंतु यस फोर
Item-
पेज
Page 4,
Item 20 mile.
22, 26.
again
Whose time I Item 20.
डेट करंतु सुबेरे
We consider 3 years.
रिकमेंडिंग 3 है
Yes.
21-24 27 to 35
Lordship, item 34, your Lordship.
34
On behalf of S. Mahapatra, your Lordship.
34 तो लेखा मिस्टर मार्कस 34 आपण ते adjournment जाऊ आपण कोण राहणार सर
आदेश जना.
आता ना ना नाही
No.
पोस्टिंग कर दो
We consider 17.
Item 30.
Item
number
31,
36, 37.
31 काउंटर फाइल है नहीं
মানে তাদের আগের করতে স্কিমটা
31 amnesty
যাইছে
তাহলে ডিসপোজ অফ कर दो भाई
সে যাও 2 মাস পরে আসু যদি কিছু অর্ডার হইতো সে পর্যন্ত কিছু অর্ডার ফাইনাল অর্ডার পাস
नहीं
করবে
नहीं महांती
ଆଜ୍ଞା।
कोर्ट कहवा ताकू बुझेई की कहवा देखो केते कथा बुझेय पड़ुची सर
ଆଜ୍ଞା
आपण जे कोर्ट ऑर्डर नेबे तार इंपैक्ट अलग
dispose
तापर केस यदि डिस्पोज ऑफ
ଆଜ୍ଞା।
हेल के आपण ये हेले एग्रीड हेले आ गोटे केस करिवे
ଆଜ୍ଞା ଡିସପୋଜେବଲ
so both of you are happy
ଆଜ୍ଞା।
both parties happy you are happy
ଆଜ୍ଞା
नहीं I am not saying but you must have a perspective
ଆଜ୍ଞା
मोर जा 31 रे कोन अछि रेकॉर्ड रे एमनेस्टी टा
ଆଜ୍ଞା
लेटर टा आपण देछन
ଆଜ୍ଞା ଆଜ୍ଞା
एमनेस्टी डिस्पोज्ड ऑफ करते ऑर्डर टा डॉक्टर तुमना कुछ 31 है
31 36 37
36 कोन एमनेस्टी
ଆଜ୍ଞା
तीनटा
ତିନଟା
amnesty 36 amnesty कोन भी लिखि रखो 37 आउट से
37
amnesty अछि
ଆଜ୍ଞା
कोन क्लाइंट को कन्विंस करंतु से बेट दे बी सैटिस्फाइड बट यदि amnesty वर्क्स आउट नथिंग लाइक
item number
तर
20
आउट पाउट जिंस ला it closes the litigation
Ma'am.
once this offer amnesty and you accept
my lord
either they can never reopen it yeah sir
I am 29 my lord
29
I am this part number 4 2 weeks after
other side
Mr.
Mr. Mohanty
yes ma'am
posting करतु
We consider 17.
oblige
आगे
29.
सिंपली ऑर्डर के लिए समय लगे कंप्यूटर ने कर दिया पोस्ट
44
17-8 है मिस्टर मोहन
item 44 my lord
पेज पे जाए कौन 36 पेज पे वाले नहीं नहीं देखो देखो
Page 6, 38 to 42.
नेक्स्ट
Page 7, 43 to 45.
44 my lord
Yeah.
for adjournment
44 month अच्छा
We consider 17.
what happened to your eyes sir you are not taking care of
Allergy.
Huh?
Allergy.
it at least you should use a glass जोटा कि brightness आसीबो the brightness creates more problem ଆପଣଙ୍କର ବନ୍ଧୁ Come back. Call the list.
Vehicle list to be mentioned item 1.
ଏଇଟା କଣ ଥିଲା କି ଯୋଉ ଦେହ ଖରାପ ଥିଲା କହୁଥିଲେ? ନାଇଁ ନାଇଁ ସେଗୁଡା କୁହନ୍ତୁନି, ଏଇଟା ପର୍ସନାଲ କାମ ନୁହଁ। ରିକ୍ୱେଷ୍ଟ କରନ୍ତୁନି, ଆପଣ ଲିଗାଲ ସବମିଶନ କରନ୍ତୁ। ୟୁ ହାଭ୍ ଏଭରି ରାଇଟ୍ ଟୁ ରିକ୍ୱେଷ୍ଟ। କୁହନ୍ତୁ କଣ ହେଲା, ଆଗକୁ ଆସି କୁହନ୍ତୁ କଣ ହେଲା, ଆପଣ ଏଥିରେ ପାୱାର ଅଛି।
Yes, my lord. I come from Barampur. This is a contempt case, madam. My lord.
ଓହୋ ମେମୋ ସକାଳେ ସରିଗଲାଣି ମେମୋ। ମୁଁ ଭାବିଲି ମୁଁ I thought he's your associate.
No, no. Your Lordship, the same was.
ତାହେଲେ ଏଇଟା ଆଉ ଗୋଟେ ଦିନ
So let the Your
ମିଷ୍ଟର
Lordship.
ଦାସ ଏଇଟା ଏଇ ୱିକରେ ହେଇପାରିବନି ସୁସ୍ମୃତି?
He's hospitalized. I don't know. He's in a critical condition. So let whatever Your Lordship passes the order.
No, no, no. that I need to do.
But
ମୁଁ ଯଦି ସେଇଟା 2 ବର୍ଷ ତଳେ କରିଥାନ୍ତି 2 ବର୍ଷ ହେଲା କେସ୍ ପଡି ନଥାନ୍ତା, ଡିସ୍ପୋଜାଲ ବି ବଢି ଯାଇଥାନ୍ତା। ସୋ ଆପଣ ଦେଖନ୍ତୁ, ୟୁ ଟ୍ରାଏ ଟୁ ସର୍ଟ ଇଟ୍ ଆଉଟ୍ ଫର ହିମ୍ ହ୍ୱାଟ ୟୁ କ୍ୟାନ୍ ଡୁ। ତାଙ୍କ ସାଙ୍ଗରେ କେହି ବି ନାହାନ୍ତି, ଏକୁଟିଆ ସେ।
So he has already engaged
Hey,
the document. Madam is.
he had signed the paper and sent me in my WhatsApp. So I got a printout that if Your Lordship, I can. He is engaging me.
Absolutely.
That-
Mr. Das,
Okay,
you
if-
keep it. You
if
keep
this
it with you. No, that is for court, I think.
Yes. If this,
ସେଇଟା ଆପଣ ରଖିଥାନ୍ତୁ। ଆଜି ଏଟା କୋର୍ଟରେ ଫାଇଲ କରୁଛନ୍ତି।
if this will do, I
ଗୋଟେ
can file
4 ଟଙ୍କା ଲଗେଇ ଦିଅନ୍ତୁ। ମେମୋରି କେତେ ଟଙ୍କା ଲଗୁଛି ଏବେ?
memory poison.
ନା
Memory could feel like
memorandum file not filed in court. Memorandum of a lawyer. ଆପଣ at this age and experience
it's not a memorandum. It's
ସେ ଯାହା ବି ଅଛି ଚଳିବ। ସେ ଯୋଉ ଫର୍ମାଟ ଯୋଉ ନାହିଁ ଗୋଟେ ପ୍ରିଣ୍ଟେଡ
Right,
ଫର୍ମାଟ, ଆଉ ଏଟା କଣ ହବନି? ଇନଫ୍ୟାକ୍ଟ ମେମୋରାଣ୍ଡମ ରେ କି ମେମୋ ହିଁ ଲେଖା ହଉଛି, ମେମୋରାଣ୍ଡମ ଲେଖା ହଉନି।
I'll file that. I'll file.
ଏବେ 4 ଟଙ୍କା
That in that.
ସେ ଗୋଟେ ଛୋଟଟେ ନାହିଁ,
ଆଜ୍ଞା ସେ
ସେ ବଡ।
6 ଟଙ୍କା
6 ଟଙ୍କା
ମୁଁ ଲଗେଇକି କରିଦେବି।
କରନ୍ତୁ। ଏବଂ ଆପଣ ଜଷ୍ଟ ଟ୍ରାଏ ଟୁ ଡିସ୍କସ୍ ୱିଥ୍ ମିଷ୍ଟର ଦାସ। ଆପଣ ଯୋଉ କଭର୍ଡ ଅର୍ଡର ଗୁଡାକ ବି ଡିସ୍କସ୍ କରନ୍ତୁ। ଗୋଟେ ସାମ୍ପଲ ତାଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ।
I've already here
Bas.
submitted.
So you fix a date, you decide.
Accordingly, this only one prayer that the matter, though it is remanded back. So only I pray that a certain time may be fixed up so that it can be disposed of easily. Because these private people,
That is there.
Constitution
it is only expeditionally.
there and constitution. First of all, the trial court has violated constitutional order, bench decision, but referral courts. Now the High Court will violate the constitutional bench decision.
Whatever your lordship.
So if that you can always make, as I was telling, you can always make a prayer if that is the only case pending. Please appreciate what the Supreme Court has laid down. That is not the only case, but I have highlighted that.
Yes.
Yes.
In fact, I have gone to the extent of highlighting that it is the acquisition of
Yes.
gold. Instead of referring to the reference, I'm going to the acquisition date, and try to inbuild certain mechanism like he doesn't appear. Then court and lawyer cannot do anything.
No, I cannot.
Like the person saying that lawyer doesn't cooperate, I want to withdraw. You never know how it will go, how it will unfold. So that in that scenario, so expeditious.
Whatever.
That comment of the Supreme Court that what High Court should not do is doing every day is in expeditious trial. ତାହେଲେ ଆଜି ଡିସ୍ପୋଜ କରିଦେବେ ତାହେଲେ ସେଟା ଆଚ୍ଛା
4 matters are given.
ସବୁଥିରେ ନେଇ ଆপিୟରାନ୍ସ ଦେଖିବେ ମିଷ୍ଟର ସୁମନ ମୋଦି ଅନ୍ ବିହାଫ ଅଫ ଏଟା କେତେ ନମ୍ବର ଏଟା First, except Sathak Pradhan.
61,
Except
66.
62 minutes. Except 62 all other. All four of them. 61, 63, 65 and 66.
62 रे कौन क्या appear कले नु?
No, my lord, I have tried that day also and
63, 62, 63, 65, 66.
66.
आपण मानकर appearance उडाटी लिखी दियो. Mr. Lenka, in all,
Yes.
ये central government kindly write your names. ଆପଣଙ୍କର ଯୋଉ ଏତିକିରେ ରହିବ appearance ଯାହା ଅଛି ସେୟା ରହିବ.
List ରେ ଦେବେ।
ଟ୍ୟାପ ଗୁଡା କରିବେ ମୁଁ ତାପରେ ତାକୁ edit କରିବି. ଏଟାକୁ ଆପଣ judgment reserve କରିଦିଅନ୍ତୁ. ଆପଣ ଟିକେ pressure କମିଯିବ. You are overburdened. Actually, for the last 4-5 days, the things are piling up.
ଏ ଓଲ୍ଡ କେସ୍ ଥିବା ଯୋଗୁଁ ଆମ ପାଖରେ କିଛି କପି ନାହିଁ ତେଣୁ ଆମକୁ
କପି ଗୋଟେ ଦିଅନ୍ତୁ. ଦାସ ଦେଇଦେବେ. ସେ ଆଗରୁ ଦେଇଛନ୍ତି ସେଆକୁ ଦେଇଥିବେ ଯେ ଏତେ ତ ଆପଣ
ହଁ ନିଶ୍ଚୟ ଦେଇଥିବେ ଆମର ଯୋଉ ଚେଞ୍ଜ ଏଦିନ ହେଇଗଲାଣି କିଛି ଅସୁବିଧା ଏଟଲିଷ୍ଟ ଦେଲେ ବି ଆମେ ଜେରକ୍ସ କରି ତାକୁ ସ୍କାନ କରି
ସେ ଆର ମ୍ୟାଟର ତ ଦେଇଥିଲେ ନା
other matters that they
ଦେଇଛନ୍ତି ଦେଇଥିଲେ ଏଇଟା ଦେବେ ଆଉ।
copies are given, but
Sir.
in item 61 there was no copy. Some of the copies are given.
ଟିକେ
I'm
ଚେକ୍ କରିଦେବେ.
giving.
You will check it.
I'll
Judgment reserve କରିଦେବେ.
but 62 the
Kali as-
respondent, private respondents are not appearing.
କାଲି ଆସୁ ଦେଖିବା 62 କାଲି ସେ ଟୁ ଡିମେନସନ ଆଣିବ ସବୁଦିନ ଆଣ ଅର୍ଡର ପାସ୍ କଲେ ଫେର ଦସ୍ତଖତ ହବ ଯିବ ଲିଷ୍ଟ କୁ ଯିବ ଇଏ ହବ ସିଏ ହବ ଏମିତି ଚାଲିବ ଫେର ନନ୍ ଆପିୟରେନ୍ସ ନୋଟ କରିବା ପାଇଁ
In earlier medical.
ସିସିଟା କାହିଁକି ଇଏ ଲାଗୁଛି ମାନେ ଚଷମା ଦେଖାଯାଉଛି କାଳ ହେଇଯାଉଛି ଚାଲିଛି ଠିକ ଅଛି ଟିକେ ପରେ ବୋଧେ ତାମାନେ 62 କାଲି ରହିଲା ଟୁ ବି ମେନସନ କେନ୍ଦ୍ର ଆଣିବେ ଆଉ 61 63 65 66 ହାର୍ଡ ଜଜମେଣ୍ଟ ରିଜଲ୍ଟ ସେ ଅର୍ଡରଟା ବି ଡାକିଦେବ ନହେଲେ ଗୋଟେ ଅର୍ଡର ଡାକିଲେ ଆପଣ ଦଶ ଗୁଡା କରିଦେବେ ଆଜିର ଅର୍ଡରଟା ଲେଖନ୍ତୁ ସୁଶାନ୍ତ କୁମାର ଦାସ ସିନିୟର ଆଡଭୋକେଟ along with Mr. Praveen Das for the appellants. Ms. Suman Moti on behalf of Sathak Pradhan for the respondent. State होचंती UP 13 तो TN लेंका इतरे अपना आपको रेलवे की पार्टी करना है
No, my lord, they were not there. Initially, the bad news have
एबे कर दियो
Well,
नॉन से डिफेक्ट कैन कंटिन्यू एक्चुअली लीव नहीं की इम्प्लीट करिवार थिला
no, wherever in the previous matters, Lordship had already directed the railway to also file implementation petition.
they have to so but they are not respondents तापरे देखिए मिस्टर पीके पाड़ी सीनियर एडवोकेट along with so and so लिखा देबे
In 61 SK running on this.
दे दियो से तांकर होटल लिखछन ना जो भूल भाला along with so and so for the newly added OP number 14 it is submitted newly added pro forma opposite party say pro forma hai because they are with you or what do you say
Performance.
pro forma hai so Das Learned Counsel Lord Senior Advocate for the appellant submits that before the referral court in the proceeding under section 18 of the Land Acquisition Act, 1894. The present appellants were not parties, as well as so also the Union of India, Ministry of Railways, East Coast Railway, were not parties. Though the appellants claimed enhancement of compensation that was awarded and received by them. He submits that leave may be granted to. Upon the leave file करचंदी
My lord, Leave has already been
allowed.
allowed.
अच्छा ठीक है जी. He submits that in IA number कितने 189 of 20222 leave has been granted to move the appeal before this court, which has been allowed by order dated.
That is, the leave application was 189 of 2020.
Allowed on
14/12/2022.
14/12/22.
14/12/22. IA number.
Allowed by order of this court dated 14/12/2022. Hello. This was submitted. It is submitted by the learned counsel for the appellate, that or the senior counsel for the appellate, that since railways, since Union of India oblique Railways oblique East Coast Railway are also vitally interested, and ultimately their owners are confident. Ultimately, and being the ultimate beneficiary of the acquisition of land for construction of railway track, they need to be pleaded as pro forma opposite party. He submits that he submits that leave may be granted to impede the Union of India oblique Railways as pro forma OP number 14. Para leave granted where is allowed. The learned asserting counsel, Mr. P. Das, is permitted to carry out the necessary addition of pro forma opposite party in the cause title of the brief. The same shall also be indicated in the copies served on the learned counsel for the respondents plural. This is Modi and the learned counsel appearing for the state and a DG. Stop. Copy of the appeal memo shall be served on the learned. नहीं सर आप यूनियन की अच्छी पार्टी साहब नो संगर
In 61,
हाँ
myself, SK Samant.
तो इसके समांतर CGC during course of the
Along
day
with current days. Along with current days.
लिखा है during course of the day. It is submitted by the learned counsel advocate that the matter, the appeal, the issue raised in the appeal, particularly the legal issues, is no more res integra in view of the judgment rendered by this bench. This time,
7 July 2020.
By the division bench, as well as the coordinate bench. Coordinate bench also Pitambar Sahoo, नहीं क्या? इंडिया को देवे आपण जोटा ए बेंच रो जोटा लीड गोटे फास्ट डिसीजन टा दे दियंतु सेटा गोटे हला डिवीजन बेंच जस्टिस डिवीजन बेंच अछि ऑनरेबल जस्टिस सडनली कर दरकार
Already indicated in the last order.
ठीक है
All the previous orders.
ऑर्डर
are mentioned there.
साइकिल से तो मते देवे बेस्ट सेटल फिलर ओनली नो मोर एस इंटीग्रा. It is submitted by the learned counsel for the respondents appearing on behalf of the submitted by Mrs. Modi, learned counsel appearing on behalf of Sri Pradhan for the respondent submits that due to as Mr. Pradhan is unable to appear, she has been authorized to represent the respondents. Sri Pradhan has issued a memo which she shall file during course of the day. इटी दे देबे बेटा this the memo shall be accepted and taken on record, scanned copy to update it. आपण कोन गोटी आनछन
Only one.
सेतिर सबुजा केस नंबर पकांतो you have to be innovative सबुजा केस नंबर पकेई की आपण दियंतु ताको जेरोक्स कर देबे केतरा मैटर ले चारिटा
4 cases
सो चारटा जाकरे आपण गोटे ओरिजिनल आ तीनटा
and 4 appearance memo.
तीनटा करते आडिया दरकार बट सबुतरे से 4 टका ना 6 टका लगे देबे
Okay.
It is submitted by Mrs. Modi that due to the health condition of the Senate councils, he could provide one memo authorizing her to represent the matter, represent the respondents, and she shall file photocopies of the memo in all the applications. In connected appeals, not all connected appeals, LAA 63, LAA 65, LAA 66, which are also taken up together. Hearing concluded, judgment teacher.
Fix up a date if possible.
Appearance date का कौन suggest करो? Respondent, अपना copy of this I don't know how could I miss it actually. The appellants take steps for forwarding copies of this judgment. सेदिन करियो नहीं कि pronouncement दिन लिखित है थोड़े. Appellants shall take steps shall file requisites for issuance of copy of this judgment to the appellants in their address given before the referral court as well as given in the cost title by registered post, speed post with registration and proof of delivery. That much extra you have to do.
For the respondents,
Private respondents. The seତେବେଳେ ଲେଖିବେ ଏଟା orderଟା separate କରିବେ. Information ପରେ. The requisites shall be filed within 7 working days ସେତେବେଳେ କରିବ ନା. Date केबे कोन?
Immediately in August, second week or third week.
14th 14th August. So बुडाका 14th August Mr. Party Mr. आपण माने भी सेठी appear करिवे ना जदी आपण के का
Yes. All will have copies.
But this order will be followed in 65 only because in all other matters, secretary is a party. So in
No,
only
that I will take care. I just going to tell that. ଆପଣଙ୍କର ରେଲୱେ ଯୋଉଥିରେ ପାର୍ଟି ଅଛନ୍ତି ଫାଷ୍ଟ ଯୋଉଟା ଇମ୍ପ୍ଲିକେସନ ଟା ରହିବନି ବୁଝିପାରୁଛନ୍ତି ଟିକେ ଦେଖିବେ କଷ୍ଟ ଟାଇଟଲ ଦେଖିଲେ ଜାଣିପାରିବେ. चौदह आठ बुझे 14/8 ମାନେ ଆପଣ ତା କେବେ ରେଡି କରିବେ 20 ହେଇଗଲା ତାହେଲେ 21/8 କରିଥିବେ 21/8 ଏଇଟା ଆପଣଙ୍କ ଉପରେ ମିଳିବା ଦରକାର ନା. ତମର 27 ଅଗଷ୍ଟ ହେଇଥିଲା 17 ଅଗଷ୍ଟ ହେଇଥିଲା ନାଇଁ ନାଇଁ ଫ୍ରାଇଡେ ହେଇଥିଲା ନା ଫ୍ରାଇଡେ ହେଇଥିଲା ଆଚ୍ଛା ଅଲଗା ଅଲଗା ଡେଟ୍ ଥାଉ ସେ ଏଇଟା କମ୍ପ୍ଲିଟ ହେଇପାରିବ ଭୁଲ ଭାଲ ହେଲେ ଅସୁବିଧା.
there are 4 matters.
They come under pressure when I pronounce immediately and so they go on. साथे कौचंद ना
साथे
साथे आपण 17 मने ठीक थाउ अलगा थाउ ते एका डेट करी हो आज 20 तारिख है. Thank you Mrs. Modi, this will help these land users if they want to get anything. Only way is that the other side should be heard. At least your the challenge is only confined to non impletion of project property. So that point goes.
सर 62 कल
बस सबुदिन आनंतु देखियो LAA 62 of 2022 Mr. Sushant Kumar Das 62 रे की अपेयर ना देचंती सामंतराय
Council's name.
डिविजन ठीक है ये सब ना लिख देवे ना 62 डायरेक्टर्स लिख देवे it is submitted by the instructing counsel Mr. P Das that he had made efforts to contact the learned counsel appearing on behalf of the private respondents. Stop. However, no one appears for the private respondents upon call. To give further opportunity, the matters have been listed to be mentioned. Aji ke this 20. 22 kar. 22. Yes, please.
Item 2,
So, Mahanti.
BD has to take instruction.
Yes, Mr. Mahapatra.
Lordship, I entered appearance on 4th of April, my lord. Last occasion, Lordship, I received the copy from my lord and senior, my lord. I have sent it. Thereafter,
ହେଇପାରିବ କିଛି ଚେଷ୍ଟା କରନ୍ତୁ mediation ରେ
no, it actually mediation ko whatever. Actually, government, we are awaiting for the response of the government because the land was acquired by the collector, my lord. Thereafter, it was.
ପ୍ରୋଜେକ୍ଟ ପ୍ରପୋନେଣ୍ଟ ହିଁ ପଇସା ଦବ
ଆଜ୍ଞା
କଲେକ୍ଟର ସବୁବେଳେ ହିଁ ଆକ୍ୱାର କରନ୍ତି that's nothing new in your case every case so ପ୍ରୋଜେକ୍ଟ ପ୍ରପୋନେଣ୍ଟ ପଇସା ଦେବେ ଆପଣଙ୍କର internal finance ଯଦି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦଉଥିବ that's another besides the issue but it has to be paid by suppose they take from you
Lordship.
it is assumed they take from you some money even then also it has to be through the BDA ଯଦି ରାଜି ହେବେନି ତାହେଲେ ଯିବ ନର୍ମାଲ ଆଟେ ଚେଷ୍ଟା କରନ୍ତୁ
ଗୋଟେ try
ଆପଣଙ୍କର ଇଣ୍ଟରନାଲ ପଇସା କିଏ ଦଉଛନ୍ତି ଧରନ୍ତୁ ଆପଣ ବ୍ୟାଙ୍କ ଲୋନ ନେଇ କରୁଥିବେ
ଆଜ୍ଞା
କି ଆପଣଙ୍କର ଯୋଉ ହାଉସିଂ ଡେଭଲପମେଣ୍ଟ ଫାଇନାନ୍ସ ଅପରେସନ ଅଛି ତାଠୁ ନଉଥିବେ that's another thing that is not the relevant to be discussed in a land acquisition appeal ଯଦି compensation enhancement ସେ ଚାହୁଁଛନ୍ତି that has to be paid by the BDA
it was only
and in these matters that case cited by the other matter that subsequent purchasers are not required to be heard that will apply ଆପଣ ବର୍ତ୍ତମାନ ଘର କରି କାହାକୁ ଦେଇ ସାରିବେଣି
no, not for home, my lord. This was the land was acquired for the purpose of 100 feet wide master plan road, my lord.
ରାସ୍ତା ପାଇଁ ଠିକ ଅଛି ସେ ରାସ୍ତାର ୟୁଜର ଯିଏ ବି ହଉ ବର୍ତ୍ତମାନ ଧରନ୍ତୁ ଯିଏ ଡିପାର୍ଟମେଣ୍ଟ ଥିବ ରାସ୍ତା କି ଆପଣଙ୍କର ୱାର୍କସ ଡିପାର୍ଟମେଣ୍ଟ those they need not be heard ଦେଖନ୍ତୁ ଯଦି କିଛି ହେଇପାରିବ mediation negotiation basis and obviously ଆପଣ ଯଦି କିଛି ଚାହିଁବେ for reduction of the amount Mahanti will respond
Your lordship may direct for mediation, my lord.
mediation workout ହବନି unless ଆପଣଙ୍କର since you are a government entity a statutory entity unless you take a firm view on that mediator cannot tell you these things mediator cannot work it out unless you come forward and say that yes we are ready for mediation and this is our offer then at that stage it will be sent to mediation no big
Well, let your lordship may fix it to another day. I will take instruction on that this point only, madam.
So Nirmal Chandra Mahanti for the appellate. Mr. Dayananda Mahapatra. Mr. Dayananda Mahapatra, senior advocate, along with Mr. Gyanaranjan Mahapatra for the opposite party.
2.
OP2, Mr. D.N. Lenka, AGA for OP1. In response to intellectually, the matter is listed under the heading for referral to the special mediation drive 2.0 - mediation for the nation. The learned instructing counsel, Mr. G.R. Mahapatra, submits that pursuant to the order dated that pursuant to impletion of the Orissa Development Authority by order dated 10/3/2026, he has appeared and Sri Dayananda Mahapatra, learned senior advocate, has been engaged to argue on behalf of the R2. So in response to the matter to be referred for mediation, he submits that he requires further time to obtain his instruction from the R2 as well as R1. How much time?
2 weeks time.
2 सप्ताह पर रखो. The matter shall be listed. Para accordingly, the matter shall be listed on the same heading in the week commencing
3-8.
3/8. ना 10/8.
3-8.
3/8. Yes, next please.
Item 3.
Appeal करना थी. Non appeal. Next.
Here, Satyaka also.
ये appeal करना थी फॉर्म पे. 16. The matter was presented before this court on 9/11/2015 after 10 years and 10 years and 6 months. No one appears when the matter is called. The order dated 18/1/2016 by the coordinate bench had the following direction. Petitioner is directed up to Neki, filing of the receipt. Thereafter, on 18/2/2020, the matter was listed before another coordinate bench, and the following was the order. 18/2/2020. After the brief was transferred as per from the earlier counsel, as recorded in order dated 18/2/2020, none had appeared on 28/2/2020, comma 28/7/2025 on behalf of the petitioner. The matter shall be listed on 22/7/2026, indicating in the cause list, quote, shall be disposed of for non-compliance of order dated 18/16 and non-appearance since quote ends. Mr. DN Lenka appearance election. DN Lenka AG OP1. OP1. OP2 none. So notice that OP2 blank. Yes, next please.
Item 4.
Item 4, may I plead your lordship?
Yes, please. MK Mahapatra for the petitioner. Yes, please.
Your lordship, the delay of 6 days, but as per SR, they are showing that there is no delay. So
Yes.
let it be condoned.
So
And
no delay means there is no condonation required. Yes. So you have to argue on merits. That is how it has come for fresh admission.
yes, your lordship. Here, your lordship,
So what you are challenging, sir?
the impugn order at annexure 1, which is I'm husband and I've been directed to pay 5,000 monthly maintenance to my wife, your lordship.
So impugn order is not 1, it is annexure 2. That's a judgment.
Sorry, your lordship.
It's a judgment.
Annexure 2 starts from page 14.
Yes, yes. It's a judgment.
Yes, your lordship.
Yes.
Your lordship, the date of marriage was in the year 1987, your lordship. And the 125 petition was filed in the year 2019, your lordship. After a lapse of
Is there
30.
any limitation? Is there any limitation?
No, your lordship. Absolutely not, your
So
lordship.
let us be brief and crisp in our discussion.
Your lordship. Here, your lordship, the wife is residing with 4 sons, your lordship. They have ousted me from my house, and only to take some gross, your lordship, this petition was filed, your lordship.
Excellent. Actually, they are so bad, you should not maintain them. So this excellent defense you have taken in your pleadings before the trial court.
Lordship, it's a ex parte, your lordship. Though I have appeared, but I will.
So you must understand that I cannot do anything.
Yes, Lordship.
So this excellent defense of the wife and sons being bad and they have driven you out has to be told to the trial court.
Yes, Your Lordship.
So if you do not take that, and the trial court will not run after you. So,
Your Lordship.
so like your wife and children have driven you out, you have driven the trial court out. So that cannot happen. That's a figment of imagination. Court will not. So when you were set ex parte, by which order?
Pardon, Lordship.
By which order?
Yes.
You were set ex parte.
That order is not with me, Your Lordship. That
So
is.
he has now ousted you also. He has ousted the lawyer. He is not briefing the lawyer properly.
Is 16.
So did you challenge the order setting you ex parte?
No, Your Lordship. Perhaps not, Your Lordship. Perhaps not.
Still better.
Is 16. That is though the OP appeared in this case, but
So any judgment on this, that when the party prefers not to defend and takes a new plea before the revisional court, High Court, yes, that is to be entertained by the revisional court.
There is no such occasion for me, Your Lordship.
Sir, you are too candid and too honest to argue. So that is impressive.
Your Lordship.
So nothing can be done. Like it can only be adjourned, dismissed or adjourned. So let it be adjourned.
May I pray something, Your Lordship? Let this matter be referred to mediation, Your Lordship.
No. For that, money is required. I can't pay the money. There is no provision in the CPC that the court will pay money for mediation in case of maintenance.
After 30
maintenance, in case of maintenance, mediation has not evolved. If you want mediation, you pay the entire amount arrears. Go for mediation, no difficulty. You being in area, you being not participating in the proceedings at ex parte, not challenging, not honoring the court's decree, can take the advantage of mediation.
Then I will take instruction
for mediation before the trial court.
I will go to mediation before the trial court, Your Lordship.
Did you make a prayer during the proceeding for mediation?
No, Your Lordship, because
so nothing can be done, sir. Because who will pay the money? Either of us, you and me, we cannot pay the money. Court will not pay the money. State will not pay the money. You must understand that it's a decree against you, and you want mediation. What mediation the mediator will do? Unless you secure the decree or deposit the entire amount. I mean, you have missed the opportunity of defending yourself.
Yes, Your Lordship.
Possibly, after you honor the decree, in future it may help you. You may decide to challenge it.
Then regarding that,
that is a way out. That is a way out. But your strategy is that, I mean, your client's strategy is that he is not listening to anything, not to the lawyer, not to the court, nothing. So that will not work out. You talk to him. If you will secure the entire amount or pay the entire amount, then for the future, possibly they will be asked to litigate.
Yes, Your Lordship. Then I will take instruction.
The counsel for the petitioner was heard at some length. Hybrid mode, actually. The hybrid mode, the counsel being present in VC was heard at some length. The petitioner before this court is the husband in the marriage. I will लिखी दियो उनको आइए टा डिस्पोज कर दे आप पर लिखा आइए 38 लिखी में the IE has been filed for condonation of delay purportedly of
7 days.
7 days purportedly sentence after पढ़ो condonation of purported delay of 7 days in filing the revision before this court. Stop. The stamp report indicates there is no delay in filing the application, revision application. Stop. The Lord counsel for the petitioner, accordingly, the IA is disposed of. Appeal person, a revision person. Revision पढ़ो तो कौन लिखेगा? He is the husband. He is the husband in the marriage. The sixth revision of the Judgment dated 20/12/22 passed in capital C, capital R, capital P dot number 72 of 2019 by the Learned Judge Family Court, Learned Family Judge Puri. Learned Judge Family Court Puri की सब ठीक ठीक लिखी है Puri, comma favoring the said CRP filed by the wife and filed by the wife in the marriage under section 125 of CRPC into brackets since repealed and substituted by section 144 of ENSS 2023 bracket closed. Stop. The application was filed by the wife in the marriage seeking monthly maintenance of rupees 40,000. However, the learned court directed for payment of rupees 5,000 per month from the date of application, that is 25.6.2019. To support the revision, it is submitted by the learned counsel for the petitioner that the petitioner, his wife opposite party stays with his 4 sons. The opposite party along with the 4 sons have driven him out from his house. And the opposite party is not entitled to any such relief. On being asked whether such plea was pleaded before the learned Judge Family Court and evidence was laid supporting such allegations, the learned counsel for the petitioner very candidly submits that the petitioner did not participate in the proceeding before the Learned Judge Family Court. He was set ex parte. Stuff. Para now being asked whether the petitioner has challenged the ex parte, the order setting him ex parte is submitted by the learned counsel for the petitioner upon instruction. Most likely he has not challenged. Regarding regarding this aspect, the Learned Judge Family Court has observed, thus, page 16, though the OP appeared, closed. Stop. The Learned Counsel for the petitioner is apprised of the position in law that having not participated, having opted not to participate in the proceeding before the Learned Judge Family Court, by not filing any pleadings and laying any evidence, whether this court can entertain by exercise of jurisdiction, by exercise of revisional jurisdiction. The Learned Counsel is apprised of the law laid down by the apex court, authoritatively deciding this point in Samima Faruqi versus Sahid Khan, para 20. The Learned Counsel is also apprised of the provisions contained in CPC, Order 41, Parada Pura Subu Likhile. Rajesh Patel. Order 21 for appeal to money decree, that is Rajnesh versus Sehan. Paragraph so good at just click. As per your instruction, Mr. Mahapatra, no amount has been paid.
No, Your Lordship.
the learned counsel for the petitioner on being asked submits upon instruction that the petitioner has opted not to pay. Also, the petitioner has decided not to pay any amount, though as directed by the judgment dated at 20/12/22 indicated above. The amount due till today, till date is 25/19. From 25/19 to 25/26 है ना 7 वर्ष into 12 84 उन्होंने 5 4,20,000 in view of the in view of the provisions contained in the statute as well as the law laid down by the Apex Court, the petitioner shall file affidavit indicating how he will secure the amount by depositing the same. How that he will secure the amount by depositing the same before the learned Judge Family Court, public this court. In the present revision. Stop. Affidavit shall be filed within a this
Yes, Your Lordship, 2 years.
affidavit shall be filed by 3/8/2024. 5/8/2024. The matter shall be listed in the week of fresh admission in the week commencing 10/8/2024. Yes, Mr. Das.
Please.
My Lord, I just want to make a little clarify. My Lord, while disposing of the earlier matters, took note of specifically Order 41 Rule 26A, which indicates that the date and time that is to be fixed if the matter is remanded to the subordinate court. And then thereafter, it is for that court to send notice to the parties or do that.
I understand. So, considering that, so I was discussing with Mr. Taj that why I did not direct that.
Yes.
Perhaps that was in my mind.
Well, yes, I thought that if
So
that is the provision.
but now there is a problem here. The lawyer is critically.
No, my Lord, there what we are getting advantage there.
I have lost the contact with the lawyer.
My Lord, what we are getting the advantage here. Once your Lordship is remitting back to the subordinate court, and the subordinate court finds that the date is there, and your Lordship is also saying that order is remitted, sent to the subordinate court, then some of the lawyers who were appearing for the parties, they are being called by the trial court, and the matter is being disposed of in time, in all cases.
Order 41/226 सेटा लिखी दी था.
सेटा लिखी दी थी खाली, that will solve the purpose.
No. Actually, now I realize that at times I am not listing matters because somebody may be avoiding, but it should have been listed. It has created further backlog, and land acquisition appeals kept pending by court. High Court is also an issue that for long years it is kept pending. So many things. So that part, in fact, I was thinking.
No, your Lordship.
I was thinking aloud, and I have just dictated when I will pronounce the judgment. That will be the order. That order cannot be today. So since Mrs. Modi is not in touch with the person, she doesn't know who are the litigants.
No, Lord, if it is sent to that court, the trial court lawyer is there.
I got the point.
Yes, that is the reason. And in fact, that is being done accordingly in time.
Because this court is highlighting that this is acquisition, old acquisition.
For extension of time even.
Right.
Okay.
Right.
We are.
Yes. Thank you.
Item 5.
Mr. Sanjay Kumar Pradhan for the petitioner. The matter being listed for fresh admission is mentioned by the learned counsel for the petitioner, and memo of date is filed, which states thus. Packet sick. तापर लिखिबे बेसिक दरकार ठीक अछि the memo shall be taken on record, scanned copy be updated. Accordingly, the RPFM, according to the revision, the RPF, the revision application is disposed of. Copy of this order shall be forwarded to the learned Judge Family Code, Barampur, Ganja, to be kept in the records of criminal proceeding number 29 of 2018, disposed of by judgment dated 13/12/22. Will be forwarded by the registry itself. Keep what heavy lifted.
Item 6.
The party for the petitioner?
I am for the petitioner.
Yes.
The petitioner has challenged the judgment passed by the judge family.
On the side, appear kariye na?
Yes, Your Honor. My lord, I am for the opposite party on behalf of Mr. Ilkepan.
Mrs. Misra, your name is not there? Your Mrs.
My
Misra.
lord, my lord.
A. Misra.
My name is not there in the power. I am on
Sure.
behalf of.
Mrs. A. Misra on behalf of A.K. Pandey for the opposite party. Yes, what do you say? This is for what?
My lord, as instructed by my lord senior, the file is actually misplaced. So.
Okay. What about
Last occasion, Your Honor's senior opposite party senior was present and he was ready to argue. But though I was in another court, it was late. So
ता पर ही फाइल टा हजियो ता पूर्व तो फाइल हजि परिबनी
they have.
unless you get the file and get ready.
His absence.
I mean, realize the enormity or otherwise of the matter, so ता पर फाइल हजे.
My lord, let it come on
Yes.
tomorrow or next week.
Tomorrow तो ही परिबनी appearance लिख देले. It is submitted by the learned counsel appearing on behalf of the learned counsel for the opposite party that the brief has been misplaced and some time may be granted and he may be accommodated to retrieve the same. But accordingly, the matter shall be listed for fresh admission in the week commencing. What is saptah chhadti? 3-8 week rasiko na file milibo kebe laguchi milibo file ta.
My lord.
So jai parnante sir.
Actually, the clock is absent. Because clock.
आपनकर मन रखिया कथा जे फाइल न मिलिया ता अवेलेबल नाही आपनकर पेपरलेस हला पर करछंती कि एई त बहुत पुराना प्लीज एडजर्नमेंट गुडा के से आगो भले ही पने कान आगो एडजर्नमेंट ते तळु फाइल आसी कर नथिला तो जे जे मागिला एबे कोन एडजर्नमेंट माने सब फाइल सामना रे अछि
My lord, next week. Any
क्लर्क जो फाइल दिय दिन तार अलगा रीजन अछि क्लर्क जो दिय दिन फाइल से तार अलगा रीजन अछि. These are all our part of our profession and professional life. But those who did have laguni file मिलने वाले लागुनी. You don't seem to be very confident that file are मिलेगा.
next week.
Other thing,
Lordship,
Mr. Party.
I pray for
Immediate.
first. Yes,
Tell
Your
me that
Honor.
as well. ठीक है.
Item 7.
Grateful.
So, Aniruddha Das for the petitioner.
May I please? The present petitioner is the wife.
Yes.
She has initiated proceeding for claiming maintenance
Yes.
against the husband. After taking of the entirety, the court belongs to cognizance. That means primarily satisfied, notice has been issued, the opposite party appear. My specifically, before the learning court below, I am claiming maintenance for myself, my child, 20,000 and 10,000. Stating therein that the husband income is more than 10 lakhs. Even though the case has been taken up by the learning court below, he appeared. He never rebutted the allegation as alleged by myself. That is the judgment. And the learning court below Nowadays, your lordship will visualize. Learned court below awarded the maintenance 10,000 for me and to my
You seek
child
enhancement.
4,000
You seek enhancement of that.
enhancement. While there is no rebuttal for that reason, while he has admitted everything, not cross-examined, not filed any show cause for that reason. That means he has source of income.
And you were saying percentage-wise, the
That is your lordship.
is less. So Aniruddha Das for the petitioner. The learned counsel for the petitioner is hard at the hard learned counsel for the petitioner. The petitioner, you have your seat. I'll dictate order.
Well,
the petitioner before this court is the wife in the marriage. By filing the revision, C6 enhancement, filing the revision, provision like Pariva under section 19 of the Family Courts Act. C6 enhancement of the monthly maintenance granted to her as well as the minor child born from the wedlock with the opposite party husband. In sentence the awarded context sentence upon husband, then comma. By judgment dated 14/11/2025 in CRP number 27/2025 passed by Learned Judge, Family Court, Nabarangapur. He submitted that the income of the opposite party was not disputed by him before the Learned Judge, Family Court. Considering the present day expenses and cost of living, the amount awarded is frugal to sustain the petitioner and the minor child. Stop. Or issue notice along with this order to the issue notice to the opposite party along with this order. Requisites for issuance of notice by a speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to 24/8/2026. The matter shall be listed in the week commencing 31/8/2026, listed for orders in the week commencing 31/8/2026. It is for the directed that the petitioner shall continue to receive the amount directed by the Learned Judge, Family Court, Nabarangpur in CRP number 8 by judgment dated 8 without prejudice to their rights and contentions in the present application.
Can I pray before Lordship?
Yes, please.
As a for fresh admission, it will suffice because if it will be in orders, it is difficult on my part.
Sir, list distorted. You have to add. Upon active version.
No, बुढ़ा ही
You must understand. Upon the active version, upon case as well. Budget. Joda key. धर तो बुक करू नांती मेमो फाइल हेई पारुनी जेंति से कहले दोनांती आपनकर मोरी चाहिले फाइल काढू नांती
नहीं सेटा योर लॉर्डशिप knows I know while we are in both in these sides
बैलेंस करिया पड़ियो से आपण मोर एंड मोर
नहीं गोटे फ्रेश एडमिशन आसु किछ
ए ऑर्डर से आसु तो दैट सफिशिएंसी पे नोट हबो ऑर्डर से पर्पस सफिशिएंसी हबो कि नहीं दैट हैज टू
ऑर्डर से ला पड़ी
बस प्राय चेष्टा करी पडुची प्राय पडुची एटलीस्ट डिलीट तो होनी तापर नेक्स्ट डे को रोज we are trying to complete the nature of determine it is assignment achi apanka orders presentment of the hearing of cheta tike time lage
I cannot disclose
you are right
presence of bar otherwise we are facing such type of difficulty while your lordship in this side your lordship knows now we are in 14 to 16 our strength is 33 this is the condition
tapare I always grant liberty to mention so liberty to mention likhi diyo जे भी जोथरे आसो आपण मेंशन करि परिबो नो डिफिकल्ट इवन इफ आई हैव नॉट मेंशन लिबर्टी टू मेंशन यू कैन मेंशन इट
specific date
and also specific date ले गोटे बहुत टिकलिस इशू अछि आपण जेतबेले
मेंशन करिवे
सेही दिन लिस्ट हबोनी से गला इट गोज आउट ऑफ लिस्ट बिकॉज़ दे कांट चेंज इट लिस्टिंग हो कि आपनकर कोर्ट मास्टर वीक हेले कोन होछि ना आपनकर लास्ट वीक रे इफेक्टिवली दुटा दिन नथे ऑल मैटर्स कुड बी बॉडी 60 जाए पहुंचला कि लिस्ट तो ही पारला
obliged.
Yes, please.
Item 8.
Item number 8. On the
Yes.
last appeal and losses partly heard this matter, and while hearing this matter.
You are Mr. R.R. Sahoo.
Yes, Miller. Now, while hearing this matter, loss directed to obtain the certified copies of the depositions, Miller.
Which direction, please? Who direction? Direct there is a certificate copy out of the will.
No, while hearing orally this
जोटा मु करिनी मते attribute करंतुनी. A lawyer, I told you many times, the lawyer is paid for his words. Lordship directed to obtain the certified copies of the depositions. So I must know by which order.
While hearing this matter.
So while hearing and directing are different. Don't say. And I have told you several times that you can't re-argue because I have a problem in forgetting. Problem in the sense, ଆପଣ ଯଦି ଆଜି ଗୋଟେ ମୁଁ ଧରନ୍ତୁ କାଲି ମାନେ ମନେ ରହିବନି ଆପଣ କରିପାରିବେ. A lawyer has a prerogative of arguing the matter every time in a different way. Forgetting, trying to gloss over what was argued. But I have a problem of not forgetting what you argued. So that was I am emphasizing. ମୁଁ ଯଦି କହିଛି ଆପଣଙ୍କୁ ତାହେଲେ I must know the reasons why I directed to produce. So ସେଥିପାଇଁ ପଢିବା କଥା. କୋଉଥିରେ ଏଟା ଥିଲା deposition? 7 ଦେଖନ୍ତୁ. Order dated 6/7, paragraph 7.
Yes.
You have to read it aloud, sir. Nirav Pathan's role achi. It is a conversation.
Yes, ma'am. No, para 7.
It's a dialogue. It's not a monologue.
Yeah.
Kindly read para 7.
No, para 7 says, following Samimar Kharuti, Learned Counsel for the petition was requested to place whether statements were made in the written statement filed before the learned trial court, and whether the petitioner wife before the trial court was cross-examined on the contentions raised by the husband. The submitted.
So stage inshota it's a the question put on behalf of the petitioner that wife stated in her evidence before the Lord's Judge Commission, I am no more agreeable to stay with opposite part number was I was apprehensive about my life and I was subject to torture. So that clinches. This question clinches, your entire plea goes. Please. Wherein the contentions of the learned contentions raised and the arguments made on behalf of the petitioner seeking revision were noted. Stuff. Para 6 for the time to do the needful as observed will be directed in order dated 6/7/2026. Accordingly, the matter is adjourned. It will be listed for fresh admission in the week commencing.
3
Yes, ma'am. Next, please.
Item 9.
Copies are ready. No. To Gopal Charan Mahanti. Where Mr. Mahanti, sir? Upon Gopal Charan Mahanti.
Yes, ma'am. Sir, tomorrow I will solve the question because I was ill.
To Gopal Charan Mahanti for the petitioner. They are putting the exercise for it and daily ho chalo.
My love. Due to my
Learned Counsel referring to the order dated 6/5/2026 submits that he could not serve the copy on the Learned Standing Counsel. State को copy दीजिए.
State read petition.
कल Mr. DN लिखा है. PGA for the
1, 2, 3, 5.
1, 2, 3 and 5. तापर 54 लाख लिखिए कि सब तापर 54 पता करना है. Copy of the writ application and the paper and other connected to the person. And study counsel happened for the fourth year cycle of provision, which he shall do by tomorrow, within 2 working days. So receiving copy the copy after not a standing counsel, Mr. They allow Mr. Tripathi waiting for before receiving copy, they shall find their Okalatnama and after instruction. Matters has been listed for fresh admission in the week commencing.
10/8.
10/8. 10/8. हमारे भी तरफ साथ में yes, please.
Item 10.
Need to mention, according to my opinion,
Yes.
from 21 and 22. You counsel for the petitioner filed application IA for withdrawal of the writ petition on the to avail amnesty scheme.
Amnesty scheme टा आपनकर इथरे लगा है
से ଦେଇଛନ୍ତି ହଁ ତାଙ୍କୁ ନୋଟିସ ହେଇଥିଲା ସେ ନୋଟିସ ଟା ନ କହିଲେ ସେ
आइए नो ता पर नेक्स्ट क्वेश्चन को आसंतु आइए साथ ही क्वेश्चन
Amnesty scheme
amnesty scheme जो चिट्ठीटा नोटिस टा amnesty notice टा पाइले नहीं कि
notice पहले मो से notification टा अनेक्सेप्ट कर amnesty scheme लो जो scheme टा
कितने कुतरे
item 21 22
अरे annexure टा केते अछि माने item 21
ना ना annexure
पेज रे अछि कि कोन annexure ना कोन अछि कहिबे नंबर कहिबे
annexure 9 गोटा रे गोटा रे देछि
out is 16
दूसरे केते
item 21 annexure होछि 9
हमका बिग डिफरेंस सेठी देखु ना आती मु मते कहयो मु देखियो न
ना item 21 लो সেটা হচ্ছে annexure হচ্ছে 16
22 रे केते
22 रो सेटा 9
amnesty letter Mr. Tripathi. Yes. Those are the letters, correct?
Those are not letters, but he has annexed the scheme itself.
In terms of the scheme. In terms of the scheme, he will apply.
He to withdraw the writ petition to avail the scheme.
ठीक है जी आपनकर ना सर आप यो रघुनाथ सिंह that order will be passed when the matter reaches. I'll pass that order.
My lord,
Yes, please.
on behalf of my
Which item? Sorry, because someone mentioned
Item
something, I lost track.
item 10,
10. Yes.
on behalf
What's
of
your name, madam?
Sarita Mishra,
Ms. Sarita Mishra on behalf of Sambit Mahanti for the petition. Item 10.
seek
Mr.
for
D.N.
an
Linka. PGA for
seek for an adjournment, my lord.
yes.
4 and 5
1, 4 and 5. 1, 4 and 5. Corporation, have you served any copy? Fresh copies are ready. You must know this much. That is how you start. Who are the counsel for the other side, whether they have been served, your brief. Usually copies are there, lekha hai. To maintain the order sheet you maintain for your perusal and appreciation. That there you mention. Be particular.
I don't know.
Suppose you today you do not know, maybe the next time you'll be again asked this thing, or you have to appraise your senior. Possibly, copy may be required to be served. What was the earlier direction? Adjournment is sought for on behalf of the learned counsel for the on behalf of the petitioner in the absence of the learned arguing counsel. Accordingly, the matter shall be listed for fresh admission in the week commencing 10/8, 10th of August. Yes, next.
11.
So Pramod Kumar Sahoo for the petitioner. Yes, Mr. Sahoo.
Madam, petitioner is a widow lady minor.
Yes.
And
Is there any proviso in Article 226 for widow lady?
just I'm praying.
Even prayer is not there.
It's challenge the order dated 27th January 2026 passed by the chairperson of Permanent Lok Adalat Public Utility Service of London, Barampur, Maryland, rejecting the prayer of the petitioner to pay the death claim.
Order ଟା ଦେଖା ଯାଉନି ଆପଣ staff reporting ହେଇନି ଏମିତି କଣ ସିଜି ହେଇଗଲା repudiation ହେଲା ପରେ ଆପଣ ଗଲେ ଏଠିକି ଇନ୍ସୁରାନ୍ସ ombudsman ଙ୍କ ପାଖକୁ
Yes, my lord.
ombudsman ଙ୍କ order କାଇଁ usually repudiation has a remedy of before insurance ombudsman that helps you by because the ombudsman will be dealing with the facts. Did you go for that? Na jannan se provision jannanti
ନା ସେଠିକି ତ ଆମେ ଏଠିକି ଯାଇଥିଲୁ
କାଇଁ ଯାଉଥିଲେ ଆପଣ ହର ମର୍ଜ का दवा କାଇଁ ଯାଉଥିଲେ ଆପଣ ପିଇଲେ କଣ ହର ମର୍ଜ का दवा by that you spoil the case of the petitioner is already doesn't know what she is doing. If she has a claim for receiving insurance, insurance କିଛି ବହି ପଢିଛନ୍ତି? Have you read any law on insurance?
Yes.
କଣ କରାଯିବ ହେଇପାରିବନି insurance contract it is a contract, it's a contract, but it's a contract with utmost good faith. Doctrine of uberima fide, most good faith. They say that you have been suffering from cancer from your medical reports and you never reported to the insurance company.
No, the thing is,
the thing how kon habo the thing la je apno insurance re suppression of any vital information vitiates the entire upon set by pachhatir have you ever read any book or any case law on this?
My lord, kindly hear me.
No, am I unkind in discussing with you? When you do not argue, you do not prepare, do not know in fact, then why you are saying that, my lord, may kindly hear me as if I am wasting my time in discussing with you? Your lack of preparation is apparent. Just like the insurer you did not inform, you can't spoil somebody's case like this. By not preparing, not thinking, you can't spoil. I need that you are not seeking any favor. You are projecting as if you are seeking. You are fighting somebody's right.
I'm sorry, my lord. Let it come.
And I am very sorry that you are saying that you are not following what I am saying. That, my lord, may kindly listen. My whole effort of making you aware of the provision of law goes waste. If you want to argue insurance claim repudiation, what should be the preparation? Anyhow, I am not dismissing your, like, no matter I am dismissing, I am not dismissing any matter. So that's what. So I cannot say it in, at times I cannot say it in open. in a serious courtroom discussion, I cannot say that. But still, then no. Please appreciate this. Then you make your submission. But now, suppose you speak for now another 10 minutes. After 15 minutes, you are satisfied, you are exhausted. Then I have to ask these questions only. What is the nature of insurance contract? What is the contract? How it is to be enforced? Whether suppression of health condition can be a valid ground for repudiation or not. And you must understand that the person who is handling your insurance claim, his job is at stake. Because they are under strictest scrutiny. So it is because the premium you are paying is not the only amount they will be receiving that. So now you kindly start because you can continue because again after you, I would have spoken this, whatever I spoke to you for 5 minutes. So my 5 minutes is over. You can now continue. Please.
And what my prayer is, they are rejecting my application, showing the cause that underwriter not met.
You have to read your brief also to know the facts. They are because you see the brief is not ensured. Legal profession is yet to be ensured. But medicine has been ensured. Medical compensation. This is a classic case where insurance case needs to be insured. You are only reading only one line, underwriter not made, and you are not reading everything else. You read paragraph 3. Paragraph 3 of the judgment. Or say you can start reading from para 2. आपनकर मेडिक्लेम जेंति होची जे ट्रीटमेंट हम सब हो तापर मिलिबो केस रे हारि होले कोन सेटा अछि हेइ ना नाही ए बळे हेले केस रे किछ दिन पर इंश्योरेंस आसीबो because suppose she is entitled to something, she loses the case because of wrong representation. Somebody filing a case for maintenance, I am giving another example. Apono nijo case hela apono besi emotional like citing 125, she states that I am the second wife. First wife is there. Before marrying, I have obtained permission from the first wife, so I require maintenance. That's a clear case of wrong, because you are traveling on a road which leads to nowhere. By saying that before the court will never grant you maintenance. But those pleadings are filed. So city insurance kama dava. Para 2 padhuntu.
Applicant's case sworn on unnecessary details.
Sworn of unnecessary details.
Sworn of unnecessary details is that deceased P. Pandava Reddy has assured.
Kindly read.
Insured his life with respondents insurance company Bajaj Alliance Life Insurance Co. Limited for the assured sum on death of rupees 13,75,000 covering the risk commencing from 18th-12/2019 under the plan of invest assure silver wide policy number 3787758881 by paying the annual premium of rupees 55,048. But unfortunately, he died on 16th January 2020 due to heart attack at his residence. Accordingly, a death certificate has been issued by the birth and death register medical officer from Municipality of Chhatrapur. Therefore, his wife B. Chandrama Reddy, who is the applicant as well as the nominee, claimed the death benefit by submitting death claim form on 1st March 2020 to the respondent insurance company. But prior to the respondents, in their letter dated 27 January 2020, had already repudiated his claim.
Her claim. How can she become he?
Repudiated her claim on the ground of underwriter requirement not met. But that as it may be being
that as it may, print kharab hochi tar. More better hochi kaina mo itere scan copy ta enlarge kori podi dochi.
as it may being aggrieved by the reputation, she approached this forum claiming the death benefit of her deceased husband B. Pandavareddy under the policy. Para 3, respondent Bajaj Allianz Life Insurance Company, among other things, pleaded in their written statement that it is no doubt they had issued policy White 37877.
Number, don't read the number. In favor of the deceased life
In
assured.
favor of the deceased life assured for sum assured of rupees 13,75,000 with risk commencing from 18/12/2019, believing declaration made by the deceased in the proposal form are true. Thereafter, they sent for past medical investigation of the life assured. During investigation, it came to their knowledge that the DLA was suffering from cancer prior to obtaining of this policy and was not disclosed at the time of proposal, and they cancelled the policy at Murmu stage due to suppression of facts, and they have communicated the same on 27 January 2020. They further submitted on 1st March.
Anyway, since we are doing nothing, just spending time, so please examine what is a URMU. Please mark there is a period. See, he dies after within 1 month, 30 days.
Yes,
28 days. Yes. So please examine. Then kindly, interestingly, I didn't mark actually. I didn't mark this. Then kindly then read further. They further they further submitted. That URMU पर underwriter पर छाड़ दियो. They further submitted the petition is not maintainable. पढ़ो.
They further submitted on 1st March.
They further submitted the petition is not.
They further submitted the petition is not maintainable. Each as the applicant filed the present petition after knowing was fully aware that her husband was suffering from cancer. Therefore, material facts regarding his pre-existing disease in the proposal form and acted fraud as to his death without adhering to the principle of aberma fidei.
That uberima fide. So that they have also quoted.
Yes, ma'am.
So you have to understand this to argue the matter. And the other problem is that whether after they have invoked the uberima fide, then what was your response to that? Rejoinder. So unless you understand and goes there, you cannot argue this matter. The learned counsel for the petitioner was heard at length. The petitioner before this court is the beneficiary of an insurance policy made by her husband, she being the nominee. The policy commenced from 18/12/2019. Her husband passed away on 27/2020. She lost claim on 1/3/2020 into bracket annexure 3. Before that, insurance policy was repudiated by a letter dated 27/2020. Annexure 1. The learned counsel for the petitioner has time to go through the provisions under which such challenge can be made before this court. Provisions of the case law. But it is also requested to verify whether any pleadings oblique arguments were made before the learned PLA in response to the written statement of the opposite party insurance company. ऊपर जो फर्स्ट लाइन था पढ़ो तो Yes, this is the petitioner challenges which what लिखूं इसका तापर The fact would agree. तापर लिखिए by filing the writ application she challenges the award dated 27/1/2024 passed by the permanent lok adalata into bracket public utility services bracket closed comma Ganjam and Gajapati at Berhampur in PLA case number 42/2021. So the said PLA case was filed by her after her claim was after the insurance was repudiated by the insurance company insurer. What are you listening? Selection request to examine or the verify and address assist this court. For insurance ombudsman टा भी देखो तो. But it is a difficult case. से जो निजे जेटा करी चलती से most likely अपनो client को बुझाया पे एटा कर देले. जे आप किछटा उडे रहिबो बोली but it was too late in the day for him to make that insurance. धरतु से उडे treatment ପାଇଁ करी थांते कैंसर चिकित्सा रे गुडे पैसा खर्च होला हे पारुछ आजिकली कवर्ड हे गेला
एइतरे खाली गोटिया पॉइंट ପାଇଁ बोली कि मु ये करछि जहा प्रे करिया कथा
नहीं प्रे कला पूर्वरु पॉइंट टा बाहर करो
सेटा होछि खाली
पॉइंट किछि नाही आपण गेस वर्क रे सुनतु लॉ इज ए डिफिकल्ट सब्जेक्ट एज फार एज गेस वर्क इज कंसर्न आपण एवरी आर्गुमेंट इन कॉमन सेंस cannot be legal argument. That is how people the part देखिए those who are not trained in law they really struggle. आमो conversation सेमती हवा कथा न आपण सरफेस बेस्ट पॉइंट कहले बेस्ट पॉइंट तले आपण देखिना जीवरी मा डेटा आपणकर से अंडर राइटर जो लिखिले ताकू भी देखिलेनी कोन प्रोविजन अछि कोतरे सेटा प्रिपेयर हे आसंतु पॉइंट बाहर करंतु तापरे गोटे कहीं 10टा करिवे बट पॉइंट न था कि गोटे पॉइंट कहबा इज ए रिस्की थिंग इन ए legal discussion. The matter shall be listed for fresh admission in the week commencing.
10/8.
10/8. Yes. Yes, next please.
Item 12.
Yes, sir.
Yes, Mr.
Item 12 and 13. Those writ applications were filed long back in the year 2013 claiming also UGC scale of pay.
Yes.
And there were some defects also because some opposite parties were wrongly typed. And in the meantime, a lot of developments have taken place.
Yes.
Yeah, they've retired and they've got communications. And in the meantime, the Honorable Supreme Court has intervened. Lordship is also aware that direction has been given to the state government to reconcile all those cases. So they want to withdraw this.
They are in government colleges or
no private colleges?
Government,
fully aided colleges.
Fully aided colleges.
Government college teacher, they've already got nurse. Only aided colleges.
Government areas. Yes. Government college, you were also appearing somewhere. So, in contempt before Justice, Chief Justice Javeri had to give everyone 5 lakhs to get out of that contempt.
And the demonstrators also got the benefit in government colleges. So far as fully aided colleges are there.
Lost Supreme Court affirmed what is High Court Justice. It was initially single bench.
No.
Justice S.N. Prasad's judgment.
Right.
Because he made it from the day applicable, not 3 years.
3 years.
But this is a. So you're filing memo.
I already filed memo to file a better petition along with all amendment colors are aided.
It is impossible to amend actually.
Right now.
Mr. L. Samantray, senior advocate, along with Mr. Asutosh Sahoo for the petitioner. Item 12 election. 12 or 13 gote order now. The Lord Senior Counsel refers to the earlier order dated 19/2/2024, wherein a reference was made to the then pending SLP into bracket C number 6907 of 2020. Taking like that, particularly. He submits that the matter is pending for the last more than 13 years. For the last about 13 years, there are several subsequent developments which have a clear bearing on the claims of the petitioner as well as the prayer made in the writ application. So it is submitted that during pendency, the petitioner has retired from service. It is therefore submitted the petitioner may be permitted to file to withdraw the present writ application and file with liberty to file a writ petition that would include the present claim in the writ application along with that would include present note that would include the claim made in the writ application as well as the claim of the petitioner towards service benefits till date. Mr. Naik, ଆପଣ କଣ
withdraw କରିବାକୁ ଚାହୁଁ
he is very active. କଣ କହିବେ you can't say. In fact, in one matter, Mr. I have no difficulty telling the name. So J.K. Ratha asked said that why liberty will be granted. In fact, I had to omit that part.
Yes.
One serviceman in a aided college because that will create two more here. So, but Mr. Naik, it is a continuing cause of action after Justice Prasad's judgment.
Yes, boss.
Continue.
The other judgment was taken care of. Is that correct? 3 years thila jota
Tarsem
Singh cannot be applied Justice Prasad's judgment. Then it went to Supreme Court. Copy of the memo has been served on the memo paichanti.
Copy memo copy खाली code copy करते तांको देइनी sir.
Copy of the तापर लिखिबे memo dated 14/7/2026 stating the above submissions on behalf of the petitioner on record. Copy of the memo has been served on the lauded additional standing counsel. So that. Accordingly, the writ application is disposed of, granting liberty to file the same with better particulars. ନହେଲେ କୋର୍ଟ କପିରୁ ନେବେ ଆଉ ଯଦି ଆପଣଙ୍କ ନଥିବ ସେକେଣ୍ଡରେ ବି ରିଟାୟାର୍ଡ କରିଛନ୍ତି ଆଇଟମ 13
ଦିଟା ସର୍
both are retired. Same order. Yes, please. Next.
Great.
Item
Yes, please.
14.
Lordships, I'm appearing on behalf of Mr. S.K. Jafarullah. The conducting counsel is seeking for adjournment of 1 week.
What's your name, madam?
Subhashmita Patnaik.
Miss S. Subhasmita Patnaik on behalf of Sheikh Jafarullah for the petitioner. Opposite party. None. The adjournment is sought for in absence of the Lord appearing counsel for the petitioner due to personal difficulty. Accordingly, the matter shall be listed for orders in the week commencing.
Those are. Item 15.
Obliged to Lordships.
The Lord counsel for the petitioner is
may I please your Lordship on behalf of
just one second. Notice issue ହେଇଥିଲା ବହୁତ ଦିନ ହେଇଗଲାଣି ପରେ ଗଲା one second, sir. Madam Patnaik matter, I'm still there. That one. The Lord counsel for the petitioner is apprised of the earlier order dated 8/5/2026 and 18/5/2026 particularly the fact that the matter is kept pending for more than 10 years and adjournment is sought for. Let us look at further opportunity. Yes, sir.
15.
You are Mr. Das.
On behalf of Mr. Samantray, I am Samarendra Swain.
Mr. Samarendra Swai on behalf of B. Samantray for the petitioner.
Five days delay, my lord.
Adjournment.
5 days delay, my lord.
5 days delay? 5 seconds delay is delay, sir.
Delay.
Law doesn't distinguish between 5 seconds and 5 days.
Right.
Mention the 10 days.
Copy serve करचंदी.
My lord.
आपण objection ଦେଇଛନ୍ତି କି?
No objection is there. But he has mentioned it in prayer delay 10 days.
SR ରେ 5 ଦିନ ଅଛି।
ଆଜ୍ଞା।
ଆପଣ instruction ନେବେ ନା କଣ?
ଏଟା କଣ୍ଡ ନାହିଁ ତାପରେ
ନାଇଁ without instruction ଚଳିବ ତ? ଆପଣ କିଛି
ନାଇଁ
ଠିକ ଅଛି।
ଆସୁ ଆଡମିସନ ଆସୁ।
Mr. Nayak, additional standing counsel for the respondent, appellant respondent, है ना?
Yes.
The IE has been filed seeking condonation of delay of reported delay of 5 days in filing the appeal. Hard learned counsel for the appellant or petitioner as well as respondent as opposite party. Considering the period of delay as well as the explanations given in the IA supported by affidavit for condonation of delay. In considered view of this court, adequate reasons have been shown for condonation of delay. The delay authorized being for a very short period. Condonation of the same would not cause any prejudice to the respondent. Further, by condoning the delay, the matter has to be heard on merits. So, accordingly, period of 5 days in filing the appeal before this court is condoned. The IA is favored and disposed of. The matter shall be listed for fresh admission. Kebe?
Who comes in 10/8?
10/8? 10/8/2024.
16.
Your Lordship.
Yes.
Last occasion they have filed an affidavit, Your Lordship. The affidavit se the period engaged in the Council of Architecture, that is 3/2/2017 to 31/2018. That period I have not get any benefit, Your Lordship. And in paragraph 8 of that affidavit, Your Lordship, kindly see paragraph 8. Affidavit dated
Mr.
9/3/26.
A. Behra for the you are Mr. Behra.
Adhiraj Behra.
Yes, Mr. A. Behra. Mr. A. Behra for the petitioner, Mr. Aravinda Mahanti for the opposite party. और 7 टा देखंतु.
Lordship, I have already get all the benefits.
So now can I examine further as far as merits is concerned? What is the calculation? How it is calculated?
No, calculus. Your Lordship, kindly see paragraph 5. They have already admitted that period.
Unkind question pachale so jaha pachale so unkindly kochandi. You have to be also kind towards me. Am I asking you unkind questions? Kon pachali kon apun? Annamanasya kai rochon?
I'm sorry, Your Lordship.
Sorry kai rochon? Sorry what are you annamanasya? Sir, after you have received para 7, you don't dispute. Para 7 you are not disputing?
Lordship.
Now can this court examine further? What is the amount, how it is calculated? Unless the exact direction is that by the single judge.
Lordship.
So seta pacharchi apano. Apankara jodi further kichi claim rahuchi. The question is like this, Mr. Behra. If you have any further claim, leftover amount, it can be as per the direction of this court. Or if there is no such direction by this court, the only way is that you have to raise that claim. For that period, they may adjudicate, they may reject or accept. If they accept, then you are happy. Then if they reject, the lawyer is very happy. You will get another brief.
That's it. No, see.
So, merit, if you try to argue a contempt on merits after compliance affidavit, it becomes very difficult for a court. There is a direct decision on this point that court cannot enter into merits in case of a contempt.
This is not so far as
if they have not complied, you have to state that, so they will be punished.
No, they have not complied.
How do you say that? Para 7, where you have filed the rejoinder?
Rejoinder. So, Lordship, I have not filed objection to that IA.
So what can be done, sir? IA objection देबे बुझ
पाए। गोटे compliance affidavit देइचंती तार गोटे objection।
तार कोन आपण what you are denying? Court has to know. Your client's perception regarding denial is not important. What is important is that what you are denying, you are tell the court and they must know.
Lordship, that part is 3/2/2017.
सेटा orally करी होबनी।
ए सब admit करचंती।
Comply करनांती बोली। हां जब देखन तो सीधा we have not complied। कोर्ट लिखले we have not complied।
para 8 your lordship।
para 8 जे बहुत जिंस अछि para 8 सब थरे अछि।
your lordship the petition
be particular को affidavit को कोन थरे para 8
7/3/2026 last affidavit
7/3
further compliance
9/3/2026 9/3/2026
7/3 रे रिसीव बिच 9/3 हे गला फिर
7/3 बेटा
आपण एटा देखो पेपरलेस देखो तो मु जे धरची
7/3 से रिसीव कर जे
for last at least few minutes 30 seconds I am having 7/3
your
कोड आपण para 8 रे कोन हैला
it is further submitted that you know
8 रे कोन लिखा है further submitted that आपण आउट को para 8 पढे it is further to submit that see ja English lecture सेटा
I'm sorry
but English रे insurance दरकार हैला
it is further to submit here that in the present calculation sheet the entitlement for the period 3/2/17 to 31/3/2018 of the petitioner was not calculated.
A very short period I guess.
For want of complete information about the terms and conditions of the engagement. In service, conditions of service in calculation of architecture and detailed proof
calculation
of council.
Council of Architecture.
I'm sorry. Council of Architecture and detailed proof of salary and admissible dues the petitioner have received during his re-employment. After several requests to the petitioner as well as Council of Architecture, nothing has been received by the institution. However, the institute assures again.
That's it, Mr.
So
this is a clear case where content can never be made out.
Lordship, kindness. ମୁଁ ବର୍ତ୍ତମାନ already ଗୋଟେ ମୋ ପାଖରେ already ଆମର appointment letter ଅଛି let the
ଶୁଣନ୍ତୁ ଆପଣ ଯଦି ଓଡ଼ିଆରେ କହିବେ ନା ମୁଁ ବି ଭଲ ଓଡ଼ିଆ କହିବି ଇଂଲିଶ ରେ କହୁଛି ଓଡ଼ିଆରେ କୁହନ୍ତୁ ଆପଣ you have to be brief and effective in your submissions when they say that you have been requested to provide the details you have not provided or the council has not provided that you have to answer instead of giving a speech here.
I have provided your lords. I have provided.
So it can never be a matter of argument by coming to court. What you will do in facts, when you are asserting a fact before the court, what you will do? Come and argue here. What you will do? You will become mute and nod your head or what? When the court asks you to prove a fact, what you have to do?
I have to provide the documents, your lord.
No. It is got dukan chitha में देबे ना कोन? That to do in a shop. You have to state those facts in form of pleadings, supported by affidavit. You have to do it responsibly. Not a facts is never argued.
Obliged, your lordship. I will have to file an affidavit.
You need not be obliged to me. You have to oblige them to bring it on record. If you want to make out a case, or if you want to waste time like this, we can. But already it is late.
I will bring all these documents before this honorable court by way of an affidavit.
Whatever you will do, I am not advising you. I cannot also. But the way you are handling the matter, that I have a concern as a judge. If you want to assert anything, please bring it on record. Then you start.
Obliged,
but don't make a speech here.
Mu affidavit file kari anibe.
The Lord Counsel for the ଆପଣ ତ ଦେଇ ହିଁ ନାହାନ୍ତି। ଆପଣ ବୁଝିଲେ ଆପଣଙ୍କର ଶତସିଂହର ବଳ ଆସିଥାନ୍ତା। ଆଜ୍ଞା କାଗଜ ଦେଲି 1 ତାରିଖରେ ସେ କିଛି କରୁନାହାନ୍ତି। କଣ୍ଟେମ୍ନର ଚୁପଚାପ ଛିଡା ହେଇଛନ୍ତି। ଯିଏ ଆଲେଜ କରୁଛି କଣ୍ଟେମ୍ପ ଇଏ ଆପଣ କଣ କହୁଛନ୍ତି ଅସ୍ପଷ୍ଟ ଭାବରେ ବୁଝି ହଉ।
ମୁଁ 9/3
ଆଜ୍ଞା ସବୁବେଳେ ଏଥିରେ ପୁରା ଏକଦମ you have to roar like a lion, not comply, so court can punish them. ଆପଣ ତ ଯାହା କହୁଛନ୍ତି ଅଧା ଏପଟ ସେପଟ ଓଲଟେଇକି ସିଏ ଚୁପ୍ ହେଇକି ହସୁଛନ୍ତି ଛିଡା ହେଇକି ସ୍ମିତା ହାସ୍ୟ ଦେଇକି ଛିଡା ହେଇଛନ୍ତି।
court is taken to cognizance. Why should I lend?
No, obviously.
ସେଟା ତ ସିଏ ଆମେ comply କରି
He is
ଦେଇଛୁ.
confident that nothing is there. He is a seasoned counsel.
We have complied. ଯଦି any claim ଅଛି let that means
I will file an affidavit your lordship regarding non-compliance.
ସେଟା affidavit ଦେଲେ ମୁଁ କଣ ଟଙ୍କା ଦେବି?
ମୁଁ ଫାଇଲ କରିବା।
ଆପଣ ଯାହା ଦବା କଥା ଦେଇଛନ୍ତି କି ନାହିଁ ପଚରା ହେଉଛି ସେଇଟା। ଆପଣଙ୍କର ଯୋଉ 2 ମାସରୁ କମ ଏବାଉଟ ଏଟା ହଉଛି 28 25 ଏପଟ ଯୋଉ 50 ଦିନ ପାଖାପାଖିର ଯୋଉ ଆପଣଙ୍କର ଅଛି ଆପଣ ତ ଦେବେ ସେଟା କଲେ କି ନ କଲେ ସେଟା ଗୋଟେ କଥା।
ଲର୍ଡସିପ ମୁଁ affidavit ଫାଇଲ କରିବି।
ଏଥିରେ କିଛି କଣ୍ଟେଣ୍ଟ ହେଇପାରିବନି।
I have to
ଆପଣଙ୍କୁ ଯୋଉ ଦିନ ଆପଣ ଏଟା ଆଫିଡେଭିଟ ଫାଇଲ କଲେ ଯୋଉ ଦିନ ରିସିଭ କଲେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କହିଥାନ୍ତେ ଆଜ୍ଞା ମୁଁ ଦେଇଛି ସେ ଦେଇନାହାନ୍ତି ସେଟା ତ ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ କହିଲେନି।
9/3/26 ରେ ରିସିଭ କର।
9/3/26 ଯେବେ ବି ହଉ 9/3 ଆପଣ କ୍ଲାଏଣ୍ଟ ଦେଖିନାହାନ୍ତି ଆଫିଡେଭିଟ କିଛି ନାହିଁ ଆଜ୍ଞା ଏଥିରେ। The learned counsel for the petitioner was heard at length with reference to the compliance affidavit filed on behalf of the opposite parties, alleged contemnor, as well as the further compliance affidavit. He is apprised of particularly the affidavit dated para 8 of affidavit dated 7/3/2026, which is reproduced here. Reproduced in response, he submits that he shall obtain instructions from the petitioner. The petitioner is to advise shall file affidavit in response to paragraph 8 of the affidavit dated 7/3/2026. ଆପଣଙ୍କର ଯୋଉ ଅର୍ଡର ହେଇଥିଲା କୋଉ ଦିନ ହେଇଥିଲା ଅର୍ଡରଟା 8/2/2021 ରେ
ଲାଷ୍ଟ ଅର୍ଡର ୟୁର ଲର୍ଡସିପ
ଅର୍ଡର ହେଇଥିଲା 8/2/21 ରେ
8/2/21
ଆପଣଙ୍କର affidavit ଫାଇଲ ହେଲା 7/3/26 ରେ
26
ଆପଣ ଯଦି 7/3/26 ରେ ଦେଲେ ଧରନ୍ତୁ ଆପଣ 8/3/26 ରେ ଦେଲେ contempt ହବ
ଲର୍ଡସିପ
that doesn't appeal to common sense.
ଲର୍ଡସିପ 9/2/26 ରେ ଦିସ୍ ଅନରେବଲ କୋର୍ଟ ଡାଇରେକ୍ଟେଡ ଫର
ଆପଣ ବୁଝେଇବି
ଠିକ ଅଛି ମୁଁ
ରିଟ୍ ର ଅର୍ଡର କେବେ ହେଲା
ରିଟ୍ ଅର୍ଡର ହେଇଛି
ଡେଟଟା କହିଲି ଭୁଲିଗଲେ 8/2/21
8/2/21
ତାର subsequent event can never be constitute to be contempt. Anyway, ଯାହା ବୁଝିବେ ଆପଣ ଆସୁ the matter shall be listed for orders in the week commencing 10/8/2026. Rest of the matters after recess.
One thing I may payment. Item 32.
32, sir.
I am for opposite party APF. They have sought the IA for interim order. So I need to
inform କରନ୍ତୁ
and they already informed. Aditya
Mishra inform କରୁଛନ୍ତି 32 ଟା ପୋଷ୍ଟିଂ କରି ଦିଅନ୍ତୁ
ଗୋଟେ date
after notice date.
We come 17.
Any similar prayer for posting of any matter?
19.
Item
17 for adjournment ଚାହୁଁଛୁ
File memo for no inspection.
କୋଉଟା କହିଲେ sir?
Item 70.
Mr. G. Muduli.
I am for the petitioner.
Ms. Chatterjee. Rituparna.
Yes.
ଏଇଟା ଗୋଟେ ସେଟା କଣ ଦଉଛନ୍ତି ଗୋଟେ ମେମୋ ଦଉଛନ୍ତି ଲେଖିକି ଦେବେ ସେ ରଖିବେ ସେ ଅର୍ଡର ହବ ପଢିଲା ବେଳେ 18 ମିଷ୍ଟର ପାଳ ପଇସା ଦଉନାହାନ୍ତି
ପଇସା ଏକ୍ଜିକ୍ୟୁସନ ପିଟିସନ ନମ୍ବର 1 2 ଦିଟା ଆଗରେ ପଇସା ଦିଆ ଚାଲିଛି ମାରି
ଯୋଉ ପଇସା ଦିଆ ଚାଲିଛି ଗୋଟେ ଆଫିଡେଭିଟ ଦିଆ ଚାଲୁ ଆଫିଡେଭିଟ ବି ଗୋଟେ ଚାଲୁ ବର୍ତ୍ତମାନ ଆଫିଡେଭିଟ ଚାଲିବ ମିଷ୍ଟର ବେହେରା ଯେମିତି ଆଫିଡେଭିଟ ଦେବେ ଆଫିଡେଭିଟ ଦିଅନ୍ତୁ ମାନେ ଏଇଟା ଆ ପରେ ରହିବ ନା ନାଇଁ ସେଇ ସବମିଶନ ଲେଖିକି ଅର୍ଡର କରିଦେବି
ନାଇଁ ନାଇଁ ସାର୍
ଆପଣ ଆପଣ ରହିବେ ରିସେସ୍ ପରେ ନା ଅର୍ଡର ସେଇଟା କରିଦେବି ଆଫିଡେଭିଟ ଯୋଉ ପଇସା ଦିଆ ଚାଲିଛି ଆଫିଡେଭିଟ ଦିଆ ହବ ବୋଲି
ସାର୍ ପାସ୍ ଅର୍ଡର
ଠିକ ଅଛି କେବେକୁ ଆସିବ ଅର୍ଡର କରିବେ ଆଉ
ଡିଲେ କଣ୍ଟିନ୍ୟୁସନ୍ ଟା ଟିକେ କର
ହେଇପାରିବନି ସାର୍ लॉ रे नहीं अपन जो हाईकोर्ट जज भावुଛନ୍ତି बहुत बड़ से नुहंती से सब लॉ ऑर्डर 41 रूल 1 कौन अछि ऑर्डर 41 रूल 3 देखंतु लॉ रे गोटे बही पढ़िबाटा गोटे बहुत भलो जिंस आनंददायक एवं बहुत उपयुक्त उपादेय मध्य ठीक अछि केबे के दिन एफिडेविट देबे
Within 7 days.
दुई सप्ताह दियो से आसीबेनी आपण पाखु से विल अप्रोच मिस्टर रथ ब्रीफ नहीं जिवे
वो कौन सी 17
17 8 आसु नहीं 17 8 एते दिन करंतु से आकर एग्जीक्यूशन अछि मोड एमटी गले केमती हो
10
और 10 8 3 8 कर सर गोटे 3 8 कर 10 8 हो ना 3 8 सर
तो 3 8 को एफिडेविट
देखो तो एफिडेविट कौन कौन देबे कहले चारिटा धाडी रहइबो टोटल चारिटा आपण एफिडेविट लोक 60 पेज रे दोचो
नहीं सर
सुनो मो कथा बुझि साले कहले सर देबे जे को दिन देले केते पैसा देले आ को माने केते कोन मेथड रे देले केती कथा चारि पांच धाडी रे
आइटम 19 टा
यस
आ गोटे दिन को आसु आज आई एम अपियरिंग
आपण कोन से पंडा का पई
यस नो आई एम फॉर द पिटिशनर
अच्छा मिस्टर
distribution of PDS is
infructuous agreement. Matter infructuous agreement. But the renewal.
sir the brief never becomes infructuous famous story between father and son it never becomes infructuous more and more lawyers are engaged केबे को आसु आपण कहा पे
available my lord
मिस्टर महांती पीके महांती
I am appearing on behalf of the petitioner
अच्छा earlier counsel
Saroj Kumar Padi
अच्छा पर केबे वकालतनामा देइछंती
आजी देबी
आजी
काली मते देइछन फाइल टा काली थर्ड राउंड
फोर्थ राउंड होबा के फिफ्थ राउंड भी होबा
डिस्ट्रीब्यूशन टा बहुत प्रॉब्लम
that story of the father telling the son is a great story
that is sort
that sums up our profession
that order is appealable
correct so आसु सब जिंस तो हबो नेक्स्ट डेट रे अवेलेबल कोन पळेबो अमेंडमेंट हे जो वर्स्ट केस कोन हबो अपील टा उठी जीवो केबे केबे कसले हबो
प्रेशर होची
अगस्त
शॉर्ट डेट
अगस्त 18 छाडी के
सर शॉर्टेस्ट डेट दिया मु शॉर्ट डेट भी देखु 10 8 वीक रे आसीबो
फास्ट वीक रे
10 8 वीक रे आपण पर डे ना कोन आपण यूनियन पेन होंती यूनियन ऑफ इंडिया पेन होंती आपण
Private body.
ओ सेटा
नहीं एटा
सेति पाया प्राइवेट पगा सेटा मिस्टर महांती आपण यूनियन प्राइवेट को तफात किछि नै डेट हेले
It is short term, private is long term.
ठीक शॉर्ट टर्म नो मनी इज नेवर शॉर्ट टर्म सर
नहीं money is
दिस इज नेवर शॉर्ट टर्म
interim order to continue
आपनकर ब्रीफ एरिका भाई टाइम नेबे नियो
नहीं
जिंस रेडी रखो
आज्ञा
Item 17.
So the concern mostly for the Hon'Ble for the petitioner. Ms. Rituparna Chatterjee on behalf of Amit Prasad Ghosh for the opposite party. You have it. You have it. Order dated 272026 para 1. On 152026, the following order was passed. normal type of same order, shorter margin, normal type. Thereafter, 272026, the following was passed. 2, 3, total. Today, the matter being in the list, the matter being listed under the heading for orders. Memo of date is filed by the Learned Counsel for the petitioner, which states thus. To bracket CPSIC. Apparently, after filing of the case, the petitioner is not prosecuting the matter. And sufficient indulgence has been shown by this court. As directed by earlier order, dated 20/7/2026, is indicated in the cause list. The matter shall be disposed of within court line. The matter shall be disposed of court ends. Accordingly, the petition is disposed of. In view of the above, the petition is disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court Dhenkanal to be kept in the records of CR.P. number 01 of 2021. Disposed of by judgment dated 28/6/2022. Objection shall be forwarded by the registry.
7/18.
Mr. Ramanath Pala for the petitioner, opposite party blank. IA mistake लिखी IA plus RPF. The revision application is filed by the husband in the marriage seeking revision of husband in the marriage under section 19 of the Family Courts Act, 1984, seeking revision of the judgment and order dated 4/5/2022, passed by the Learned Judge Family Court, Khurda, at Khurda, in criminal proceeding number 167 of 2019, thereby allowing the application under section 125 of CRPC to bracket so and so, bracket closed, filed by the wife in the marriage and the minor child born from the wedlock, seeking maintenance, monthly maintenance. Yes, the order 41. So, paragraph order 41 338. The Learned Counsel for the petitioner is apprised of the provisions contained in the Civil Procedure Code, particularly order 41. So. It is submitted by the Learned Counsel for the petitioner that the petitioner goes on paying the maintenance as directed by the Learned Family Court by judgment and order dated 4/5/2022. Accordingly, it is directed the petitioner shall file affidavit indicating in brief the details of such payments made, that is, date of payment, amount paid, mode of payment, total amount paid, till date. Affidavit shall be filed by affidavit shall be filed by TDC 7/2024. The matter shall be listed for orders in the week commencing 3/2024.
Item 19.
Petitioner blank. 19 State Council के इसमें पता लिखो 19 मिस्टर नायक पता पता मोबाइल लिस्ट ले दे दे State Council OP 1 2 and 3 OP4 blank the OP4 Gyanananda Ponda blank J.N. Ponda is submitted by Mr. Anupam Ratha, Learned Counsel, that the petitioner has obtained change and he has he along with his learned it is submitted by the Anupam Ratha, Learned Counsel, that the petitioner has obtained change and he has instructions to appear on behalf of the petitioner after the petitioner has obtained consent from the Learned Counsel who was appearing earlier. Stop. The Wakalatnama, it is submitted that stop. It is submitted that Wakalatnama, duly executed Wakalatnama on behalf of the petitioners is being filed today in the registry. Stop. The Wakalatnama shall be taken on record, scanned copy be updated. Upon filing of the Wakalatnama, name click. Upon Wakalatnama being taken on record, names of Mr. Anupam Ratha, Learned Counsel and Learned Associates shall be indicated in the cause list as well as the case brief. The Learned Counsel for the OP4 objects the prayer for adjournment, submits that the matter being unnecessarily adjourned by the petitioner in one petition of the other. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing. Dosa 8 20 Sorry, sir.
Item 20.
Mr. A.K. Behra for the petitioner. It is submitted by the opposite party blank. It is submitted by the Learned Counsel for the petitioner that as directed by the order dated 26/6/2026, the petitioner is yet to file the affidavit and further time may be granted. Stop. Para. Accordingly, the matter shall be listed for orders in the week commencing 3/8/2026. The petitioner shall file affidavit as directed by order dated 26/6/2026 by 30/7/2026. Next, please.
Item 21.
Mr. Raghunath Singh for the petitioner. Mr. Amarinder Prasad Ve, along with Mr. N.D. Tripathi for the opposite party. Learned Counsel for the petitioner as well as the Learned Standing Counsel on behalf of the opposite party. You have your seat, Mr. Singh. Wait. State Council key. कॉमन आइडिया आपको इतने समय में कोर्ट देखचुनी कहले देखचुनी कोई पर नहीं गोटे जणा सज्जानंद कहला पर रहले आ गला सरला कोडिया रे की अछंती
ओडिसा रे सचिव
आ 23 रे
23 रे
26 रे 26 रे ଆଉ ଆଜ୍ଞା
I'm sorry, I'm there for in 23, madam.
20 ରେ ସତ୍ୟାନନ୍ଦ ନାୟକ ତାହେଲେ 21 ସତ୍ୟାନନ୍ଦ ନାୟକ ରଖିଦେବେ ଟିକେ ଭାବିବେ ନା ମିଷ୍ଟର ସ୍ଟାଣ୍ଡିଂ କାଉନସିଲ ଯୋଉଟା କି ସେ OP1 OP2 ମିଷ୍ଟର ସତ୍ୟାନନ୍ଦ ନାୟକ ଆଡିଶନାଲ ସ୍ଟାଣ୍ଡିଂ and learned counsel for the petitioner and the learned standing counsel for the OP number 1. The petitioner refers to the annexure 16 to the annexure 16 that has been annexed to the IA number 13298 of 2026. IA ta reads are missing like IA and I think like so refers to a thing and submits continuation, not para, continuation, and submits that the petitioner seeks to avail the opportunity of amnesty as per the amnesty scheme introduced by the OP number 1 authority, circulated by office letter dated 24/7/2025 to all additional commissioners, public regional directors, etc., issued by the joint director revenue, Employee State Insurance Corporation, into bracket, Ministry of Labor and Employment, comma, Government of India, bracket closed. Manchiti Bhavan, New Delhi. It refers to and therefore accordingly and submits that. Full stop ହେଇଗଲା full stop ତାପରେ amnesty order ଟା reproduce କଲେ edit କରିବାକୁ ପଡିବ କାରଣ scan copy ନାହିଁ scan copy ପରେ ଯୋଉଟା ଅଛି ସବୁବେଳେ ଗୋଟେ letter ଟା annex କରୁଥିଲେ scan copy scheme ଟା annex କରୁଛନ୍ତି so এটা annex କରିବା ଆବଶ୍ୟକତା ନାହିଁ ଅବଶ୍ୟ the said scheme এটা କେତେ runs into several pages ଅସୁବିଧା ଏଟା ଅସୁବିଧା letter ହେଇଥିଲେ better ହେଇଥାନ୍ତା ଠିକ ଅଛି disposed of ତାପରେ 22 so Raghunath Singh for the petitioner same appearance same OP1 ପାଇଁ ଅମରେନ୍ଦ୍ର ପ୍ରସାଦ ରେ Mr. ND Tripathi 2 ପାଇଁ Mr. ସତ୍ୟାନନ୍ଦ ନାୟକ ସେ ମର୍ଡର କରିଦେବେ ଏଥିରେ ଆପଣଙ୍କ ଆନେକ୍ସର ଟା ହଉଛି
Annexure 9.
Annexure 9 IA 13297 of 2026 with petition. ଏଇଟା ମାର୍କ କରୁଛନ୍ତି ଉପରେ ବି ଥିଲା ଗୋଟେ ଏକା ନମ୍ବର ହେଇଗଲା लिस्ट एक नंबर केमती कर दो
दुईटा को 8 टेन पड़ जाइए
मिस्टर बारिक कैन एक्सप्लेन एमती कोन हुए
ना
जेते बेसले सेते गोटे नंबर
ना
कोन करा जाय परियो कि करियो नि किछ ऊपरटा 13298 हला Item 21, IA 13298 of 2026. 22 रे लिखंतु IA 13297 of 20. अपन देखि लिखि रेस्ट इतने ठीक अछि सो अपन लेकर लिस्ट रे भूल जाई डिस्पोज्ड ऑफ नेक्स्ट प्लीज
23
I will be permitted to appear online, my lord. I'm not well today, so I couldn't go to court. Item 23, I'm for the petitioner.
You will take fresh notice?
Yes, what has happened, if your lordship remembers, my lord, lordship had directed me to take a chance by contacting the local lawyer of Bhadrak, who is appearing for the husband. I tried to contact him twice, my lord. They have been non-responsive. So what I was praying, my lord, he is working in Khuntuni. If your lordship directs, my lord,
Is he appearing before any court in any proceeding?
my lord, no, my lord. He has filed a case under section 13 of the Hindu Marriage Act for divorce. I have filed a case under 125
So in
seeking.
the 13 application, he must be appearing in his petition.
The same lawyer is, my lord, non-responsive to me. I have contacted him twice.
It will be through the court, Mr. Das.
If your lordship directs that will be, my lord.
You have to give the details of the 13 application and the name of the court.
It is there, my lord, page 15, if your lordship kindly see. Page 15.
Task of the petitioner. I wanted you to contact the learned counsel for the wife.
My lord, I am for the wife. I am for the wife, my lord.
In the lower court.
They are also being unable to, my lord, trace it.
Obviously,
page 15, if your lordship sees, my
office
lord.
note, the matter is listed for orders. The office note indicates that the notice issued to the opposite party has been returned unserved, undelivered with postal endorsement, quote, addressee left, quote ends. It is submitted by the learned counsel for the petitioner that he has also made efforts to contact the learned counsel who appears in the learned court, Learned Family Court, Bhadrak, for the opposite party husband, which has yielded no result. The learned counsel for the petitioner, present petitioner before the learned appearing before the learned judge family court, also could not help in intimating the notice public order to the opposite party. This court takes note of the fact that the petitioner, the opposite party, has filed CP number
61 of 2022.
61 of 2022, pending before the learned judge family court, Bhadrak. Which discloses his address and matches with the address given in the present application, he being the opposite party. Registry shall issue notice through the office of the learned judge family court, Bhadrak, along with copy of today's order and order dated.
Lordship's last order, my lord, it's a oral.
Notice order.
Yes, that is 1/5/2026. Order number 3, dated 1/5/2026. Lordship's order.
Notice issue. Along with copies of the orders dated, notice the 17/6
notice lordship order is one
copy of today's order along with order issuing notice dated 17/6, subsequent order dated 21/25 and order dated 1/5/26. The undelivered notice returned, copies of the undelivered notice returned shall be utilized for issuance of notice to the office of the learned judge family court. It shall be ensured by the learned court that the learned counsel for the petitioner as well as the petitioner in person receive the notice issued by this court along with copies of the orders as directed. Report regarding service of notice shall be forwarded to this court to be kept on records of this file. The learned counsel is for the petitioner shall take steps in this regard. I'll take steps for issuance of notice through the office of the learned judge family court, Bhadrak.
One more prayer, my lord. I have also, my lord, mentioned in the cause title regarding the workplace. It is in Khuntuni, Athagad.
No, leave it for now because he will be himself coming to receive the notice.
As a lordship.
Because when the court, he appears in the court, he will receive notice.
As the lordship writes.
The matter shall be listed for orders in the week commencing
10/8.
10/8. The report regarding service of notice shall be placed on record.
Grateful, my lord.
एथे जहाँ रिक्विजिट दरकार हो सेटा आउथरे दबाक पड़ी पारे.
I'll do that, my lord.
Folio ना कौन जोड़ा कहती whatever.
We'll comply, my lord.
Next, please.
Item 24.
22.
वो तो आपण सकाळे कहउथले आपण कोऑपरेट करना दे फोन धरना.
फोन
आपण सिलेक्टिव प्लान कर फोन धरछंती. Basically, I could not tell that he is scared of taking phone calls also.
Phone switch off to check.
No, he got an idea about the legal profession. I told my earlier experience 20 years back almost. I directed that. Mr. Suryakanta Dibedi for the petitioner, opposite party blank. ଆପଣ ସେ ମେମୋଟାରେ ଗୋଟେ କାଉଣ୍ଟର ସାଇନ୍ କରିଦିଅନ୍ତୁ ହେଲା memo the petitioner present in person mentions the matter submitting that she no more requires the matter she no more wishes to pursue the matter and has filed a memo signed by her which is on record. Perusal of the record indicates that the memo is available marked at flag B. The petitioner is explaining that when the Lord counsel for the petitioner is on record, she has to obtain consent to appear on her own. Accordingly, it was say order ta pura achi with nature dictation. Amito. Tapore ta lekha. And the above order was passed. When the matter reaches during course of the day, the petitioner mention the matter at the beginning of the day's proceeding. Mention the matter. So she was explaining the niceties of law as recorded in the above order, number 18. When the matter reaches during the day's proceeding, letter letter koram. से अच्छा लेटर प्रोसीजर अब अपन ट्रायल कोर्ट बहुत दिन थिली इट कॉल्ड लेटर कोन लेटर इज पॉसिबिलिटी बट से तो मेंशन कर लेवे मैटर फॉर पड़िला लेटर व्हेन द मैटर रीचेस ड्यूरिंग द डेज प्रोसीडिंग been taken up for orders. It is mentioned, it is stated by the learned counsel for the petitioner that as per the instructions issued from the petitioner, she doesn't want to pursue the litigation. The learned counsel for the petitioner was requested to put his signature in the memo available in court records, which he has done and also countersigned by the court master. But in view of the memo filed by the petitioner, memo dated 15/26, the petition stands disposed of. Copy of this order shall be forwarded to the honorable judge.
Civil
judge into bracket senior division. Ebe para kon सब senior civil judge ହେଇଗଲା बदल ହେଇଗଲା ना kon पर civil judge into bracket senior division oblique senior civil judge at Kamakhya Nagar. To be kept in the records of C.S. into bracket MAT bracket closed number 43 of 2025. Yes. Next.
25.
So Prashanta Kumar Barala for the petitioner. Opposite party black. Yes, Mr. Barala.
I for continuation of delay lordship. Delay is 230 days. But the lordship heard the matter on 8/5. Lordship directed me to take instruction how much he has paid. Late and the lordship suggested to first pay around 1 lakh, then I will not issue notice.
You take instruction. File
Yes,
affidavit. Has he filed affidavit?
No, not.
You ask him to file the affidavit. File a brief affidavit. If you are depositing anything or
Yes,
paid
but-
earlier, you mention that and file that affidavit.
File.
So appearance like that. Hard noted counsel for the petitioner is submitted that pursuant to the order dated 8/5/2026, instructions have been received from the petitioner and affidavit shall be filed within a period of
1 week after.
affidavit shall be filed within a period of 10 working days. Accordingly, affidavit in terms of the order dated 8/5/2026 be filed by the petitioner by 30. By 30, 7/2026, the matter shall be listed for orders in the week commencing 3/8/2026.
Okay.
The listed for orders.
26.
In this case, a condonation of delay has been filed for delay of 815 days in filing with this appeal mail.
Court fee देवे नहीं?
Court fee has already been paid, my lord.
आइए 24 of 2026, 26 से LAA 12/2026 है ना? The IE has been filed for extension of time to pay the court fee. As per the office note, as per report of the office, the court fee has already been paid. Stop. Accordingly, the IE is disposed of. IE 22 along with LAA. 22 to the column. IE 22 along with LAA 12 of 2026. The IE has been filed seeking condonation of delay of reported delay of 815 days in filing the appeal. Hard learned additional standing counsel for the state, appearance Prem Kumar Mahant election. For the state, he referring to the averments made in the IE, he submits that the delay has been reasonably explained by the appellants. But issue notice along with this order, issue notice to the respondent opposite party. If there have a appellant petitioner, respondent opposite party. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 working days. Returnable date be fixed to 24/8/2026. The matter shall be listed in the week commencing 30/8/2026. Listed for orders.
The IA has been filed for stay of the
execution.
Execution, yes, execution case has been filed number 3 of 2025, my lord. Before the LAR and
IA 23 of 2026. The IA has been filed seeking stay of the award dated 31/8/2023 passed by the learned presiding officer. So and so. पूरा देखी लिखी है ना? In LARR, in LA case number, Land Acquisition, Rehabilitation and Resettlement Authority, into bracket Northern Region, तो लारा कहूँ someday if Brian is ousted from his land and you file an appeal, then it becomes Brian Lara. So be careful while filing appeal for Brian. Yes, next.
Next.
So and so, so and so. It is submitted that the executing court court लिखिले कौन execution था court लिखिले नहीं कौन मैंने मुझे जाइपड़ने मैंने मुझे पढ़ले बोलूँ जानी पारुची बराबर
मतलब by letter dated 593
लेटर मो पाउ केम लिखला मुझे जो लेटर एंटरटेन करी ताल तो
they
सरिया
have informed that execution has been filed
कहाँ को लेटर लिखछन
to the office of the
आ मूव से तेरे कौन करतरी बहुत जण बहुत जिंस लेटर लिखछन अपन ये लेटर प्लेस करले अपन सेटा गुटे ताले अपन गोटे काम करनांती सेटा को अपन कोन करी अपन लेटर पाई कोन करछन पिटिशन आगु फाइल कर दैछन ଆପଣ ପିଟିସନ ଟାକୁ ଆମେଣ୍ଡ କରିଦେବେ
let impute order be stay that will
स्टे କରିଦେବି सीपीसी को था जाए लोक कहबेनी कोन आज्ञा प्रेम कुमार महंती जो आर्गु करछंती कोर्ट रे से सीपीसी कला से किछि से देखु नांती 814 दिन डिले रे मो स्टे कर देबी कंडोन न करबी
let notice को
नोटिस तो गलानी लेट आउथर को लेट आगुरु पळेलानी पर लेट माने एलईटी ना एलईटी को लेट कहउछन
LET
तो गलानी भारी नोटिस अब 10 दिन टाइम नेले नेबे बोली आपण स्टे पई करछन बर्तन कोन करी चिट्ठी पाइला पर गोटे चिट्ठी देबे गोटे चिट्ठी देबे अमेंडमेंट करे दरकार नहीं ताकू चिट्ठी देबे एवं गोटे आईए फाइल करिवे स्टे ऑफ एग्जीक्यूशन पे
हम तो आई विल बी फाइल
कोन भी से ऑर्डर 41(3) कोन हबनी के अपील रे यू टू सिक्योर द डिक्री हला केबे केबे फाइल करिवे से टाइम नहीं होत कोन देखि
1 week
काली भी गले हो आई 1 वीक का टाइम दो कोन complete call it submitted by that the executing court is proceeding in the matter as for the instruction received subsequent to filing of the IA so it is submitted that for the 1 week time may be granted to file the IA appropriate time seeking appropriate relief seeking IA seeking appropriate relief accordingly the further time accordingly the matters shall be listed for orders in the week commencing 31 ଆପଣ ଦେଖିବେ the direction to for issuance of notice in IA number 8 shall be complied MP लिख देबे steps be taken before the registry for issuance of notice in the IA number 8 से स्टेप ता नियंतु एटा को फाइल करो 13 रे चिट्ठी आसी
सेम
कोन SHM ना SAM तो चिट्ठी आसी अपन
चिट्ठी
so it is partly SAM and SHM ठीक
SAM
about the IA file करना है तो appellant file it is the same that appellant writes letters and doesn't file IA 19 चिट्ठी आसी
yes
20 रे जब हमें गोटी गोटे जीवा ठीक है LA 12 वाला LA 13
same 815 days of delay.
Just once. Let us go. It will be easier for you and for dictation also. Well, mix up page over also. In the 13 रे IA condonation होचंती IA 25 of 2026. Delay होच 815. आगो लिखिबे exemption टा IA 27 2026 disposed of. तापर 25 हे गला आपनकर नोटिस गला सेम वे. Then IA 26 रे जो ऑर्डर टा एटा हेची चिट्ठी आछि बोली ऑर्डर हि चिट्ठी आछि ऑर्डर टा लिखि परिबा सेम डेट रखि दे. हां त्रिव चिट्ठी आछि क्या सर कहउछन चिट्ठी आछि IA 19 सर IA 19 मिस्टर मोहन
Yeah, 19 delays
डिले माने अपन डेट गुडा के
485
डेट पेपर लिखियोनी सेटा चिट्ठी कथा कोन चिट्ठी पाइछन
हाँ yes
चिट्ठी पाइले छ ठीक आपनकर
yes letter is done.
आगो कोन बड़ा कॉन्स्टेंट कोन याड शुड लिखिन deficit code fit को IA 80 LAA 19 IA 80 LAA IA 80 along with LAA 19 of 2026 deficit code fee disposed of. Then 79 IA 79 of 2026
In this case there is
condonation of reported delay of 485
days.
Same issue notice. Now you come to IA 81 to stay of operation. Settere chitti aschi boli seta order hochi likhiba. Then LAA 20. LAA 20 re IA 86 of 2026 extension of time limit disposed of. Then comes IA 85 condonation of delay. Notice is there. Then you come to IA 87 of 2026 stay of operation. इतने चिट्ठी आछि
Yes.
फिर चिट्ठी order होगा. To Deepak Kumar Sahu.
Item 27.
May I please, Your Lordship?
Deepak Kumar Sahu for the petitioner opposite party flag. Notice sufficient. तापर appear करना है
नहीं
कराजियो सर
appear करना थे petitioner
फिर
before
adjournment ही थी adjournment order ही थी. So Deepak Kumar Sahu for the petitioner opposite party flag. The office note put up by the registry indicates that AD from the opposite party has been received, served, but no counsel has yet appeared. Stop. Awaiting appearance of the opposite party, the matter is adjourned to be listed for orders in the week commencing 17/8/2026.
Lord, I have filed an IA.
The interim further proceeding, the interim order dated 17/4/26. IA आपन को कौन भाई?
Interim order टा extension करिया पे prayer कर.
Adjournment order तो करी चलियो सेटा. सीआई करिया कथा ये करूना. That is the difference between आइए ताकर चिट्ठी पाइला पर कलेनी आपण उसे डिफरेंस है आपण क्लाइंट मीट करछि ताकर सेलिंग करा कोन लेख interim order dated 17/4/26 is reiterated further proceeding in CP number 270/2025 सेटा का मॉडिफाई हितला कोन आपण के आइ फैक्टले तो मॉडिफाई हेनी किछि shall remain stayed till the next date of hearing. Yes, Mr. Jena.
Seeking leave, Your Lordship, challenging the order where I was not a party. That is IA number 12919 of 26.
IA 12919 of 2026. The IA has been filed by the petitioners in the present writ application, seeking leave to challenge the order. Order dated 13/8/20 and the final decree passed in CS number 900 of 1175 of 2022, 900/1175 of 2022, disposed of by the said by the order of the said date in the National Lok Adalat by the learned senior civil judge Balaswar. Stop. It is submitted that the petitioners are
the legal heirs, Your Lord.
Are the legal heirs of the
Only one petitioner.
The petitioner is the legal heir of the
Family tree, Your Lordship. I have given it paragraph.
legal heir नहीं चिट्ठी जाती ट्रायल कोर्ट रे प्रिंट को जाती
आगे
चिट्ठी रे कहाँ रहा पड़ legal heir को
I am the legal heir of late Narayan Ponda, Your Lordship.
Narayan Ponda, how it related to
Narayan Ponda has two sons, Parsuram and Gangadhara. I am the daughter of, I am the grandson of Parsuram.
Family tree you have mentioned in
page 7, Your Lordship, paragraph 2.
7 in the writ?
In the writ, Your Lordship. I am the son of Anjali.
Referring to the genealogy presented with the writ application at page 7, it is submitted that आपण इतरे लिखिवार थिला कि कोन ट्रायल कोर्ट रे कि कोन थिले निहाती मेंशन करिया का
डिस्क्रिप्शन रे कोइ छै इतरे
हबनी सेंटी सेटा ताले जो पिक्टोरियल रिप्रेजेंटेशन रो वैल्यू कोन रहला आपण तो genealogy देखले तापर खोजिबे the present petitioner is the son of
grandson of Parsuram.
The petitioner na kono
Prahlad.
The petitioner, the present petition, सेटा से लिखिया रहला Prahlad, the present petitioner is son of Anjali, who is daughter of Parsuram, and Parsuram is the son of common ancestor Narayan Ponda. Suit kiye file kale?
Gangadhara, Your Lordship. Suit was filed by Gangadhara, but in the meantime, Gangadhara has died. His legal heirs are.
The suit was filed by the brother of Parsuram, being common descendant of Narayana, without making Parsuram branch ru kehi na thile.
Na Parsuram branch ru bhai mane hi thile. Only the sister was
without
left.
making the daughter of Parsuram a party, and only making the sons of the Parsuram a party. In the meanwhile, the plaintiff in the suit, Gangadhar, has passed away, being surveyed by his legal heirs.
Opposite party number 1 to 4.
They were parties before the trial court?
No, Your Lordship.
Surveyed by the legal heirs, OPs 1 to 4, who were not parties before the trial court and are to be and are sought to be made parties before this court. It is submitted that non-gender of the present petitioner in the suit involving partition.
Suit for partition.
In the suit for partition of joint family property goes to the root of the matter, and the judgment and decree by the National Lok Adalat is vitiated. बाहर लिख लेता having heard the learned counsel for the petitioner, leave is granted to the petitioner to take notice for issuance of notice to the opposite parties. Further prayer for leave to file, leave to challenge and file writ petition shall be considered upon appearance of the opposite parties. Issue notice along with this order to the opposite parties. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within a period of 5 working days. Within 5 working days. Returnable date be fixed to 24 24 The matter shall be listed for orders in the week commencing 31/8/24. IA 11634 of 2026. Hard loaded counsel for the petitioner. He reiterates his submissions are noted in the connected IA. He reiterates his submissions as noted in the connected IA indicated above. Issue notice to the opposite parties along with this order. And the connected IA. Issue notice to the opposite party along with the connected IA. Accept one set of process fee as well as postal requisites. Returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the judgment and order dated so and so, passed by so and so, shall remain state until further orders is further directed. Then semicolon, then subpara. Further directed, the parties shall maintain status quo regarding nature, character, possession, and ownership of the property. Schedule kind.
Schedule prayer.
Retray.
IRA, page 3.
IRA. Property more particularly mentioned in the schedule of the
prayer.
I know what author required.
That is
as per the schedule mentioned in the prayer paragraph of the IE. With regard to Moja Chakaram Rai up to
12 decibels.
Acres 0.12 decibels. Page 3 IA 1163. Mention गुड़ाक कॉल करंतु
31
30 ना अच्छा yes 31 so Somnath Mishra for the Somnath Mishra for the petitioner. So Amarendra Prasad Ray along with Mr. N.D. Tripathi for the opposite party. One and two. लिखिए IA number 1281 of 2026 along with writ petition. 5320 of 2019. Amnesty order. Post of. First opening sentence लिखो तो the matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the petitioner as well as the learned standing counsel for the opposite party. Having heard the learned counsel, the matter was taken up at the end of the day's proceeding and disposed of. After order time continue. Similar 37.
36 or 36?
36. 36 make continue. IA 6 of 2026. With WPC 15340 of 2024. Same appearance, same. Double equal to 37th. 37 में आई तो नहीं कौन देखो ना क्यों 16280
Fine.
लिस्ट नहीं कि वो ब्रीफ रहे देखो आइए 1282 of 2026 along with WPC 16280 of 2024 अच्छी different on a scan copy देखो disposed of any other matter from the hearing list Mr. Mishra
33.
No, I am not taking up. I am not opening briefs. I think pending I will try to complete them. 33. You want a date?
33.
33. If you, anyone having requesting any date, they don't. But don't insist for a date. I am a shortest possible date.
The other side is taking time each time, my lord. The maintenance case has been shared by this only.
Okay, I will take up. Jetti ki ago mane filed up achi taku tige when those matters who has been heard. No, it happened the hearing ହେଇନି.
नहीं, এটা admission ପାଇଁ ଆସିଛି.
Correct, but କେବେ ମାନେ brief ଖୋଲା ହେଇନି.
ଆଜ୍ଞା.
ନଥି ପିଟା ବେ ଯୋଉ କହନ୍ତି ହେଇନି. ଆପଣଙ୍କ matter is
38.
Yes, what do you want?
Entry order is still
ତାଙ୍କର
today.
matter ଟା କଲେ କୁନା କୁମାର ମିଶ୍ରଙ୍କର ଆପଣ କେତେ item ଟା କେତେ 33 date କହିଲେ ତ
We consider 10
10/8 week. ତ ପଣ୍ଡା
My lord, item 38, my lord.
Yes.
In this case, Lordship kind peruse Lordship's last order 85/2026.
Just one sir. I'll get the bill. 48. 1. कितने तारीख को डेट कौन सी
8/5/2026.
Yes.
Pursuant to the direction of this honorable court, notice was served upon the opposite party through the learned trial court, my lord. Despite that, nobody is appearing.
We'll take it up and dispose of. But the strategy is that I'll try to complete whatever has already been heard and completed.
During pendency of this case, some developments have been taken place. I have also annexed the copy of the divorce petition filed by the present petitioner in Bhubaneswar, my lord. And that is at
ମାନେ ଆପଣଙ୍କର ସେ ଯଦି ଆକ୍ଚୁଆଲି କରିବେନି ବୋଲି allow your prayer, no difficulty.
what has happened.
But usually, since I do not pass orders,
yes.
So I give some more time.
Why?
ଆଉ ଗୋଟେ ଦିନକୁ ରଖନ୍ତୁ ଆଚ୍ଛା ଏପର୍ଯ୍ୟନ୍ତ appear କରିନାହାନ୍ତି ଆପଣ
No.
ଆଚ୍ଛା Mr. Alok Kumar Panda for the petitioner, item 38 records. The matter being listed for hearing under the heading for admission is mentioned by the learned counsel for the petitioner to submit that despite notice being sufficient, the opposite party is not appearing, and the matter has been adjourned on several occasions. It is submitted that since adequate opportunity has been given to the opposite party, the matter should proceed in the right perspective. Accordingly, to grant further opportunity to accordingly, taking note of the submissions of the learned counsel for the petitioner, the matter shall be listed for admission
17
अर्ली चाहूँ
Any data as per convenience.
10-8 रे आसु बिल काउंटिंग 10-8 to grant further opportunity to the opposite party. Liberty to mention.
There was some interim arrangement.
Interim arrangement for adjournment.
Yes.
The interim order dated 8/5.
Well, it was passed on 12/11/2025.
12/11/2025. 12/11/2025. The interim order passed earlier is reiterated. Accordingly, is directed CMC number so and so shall be adjourned beyond a date. Kebe date कहले पर?
10-8
shall be adjourned beyond 10-8-2026 as would be convenient to 17-8. Adjourned beyond 17-8-2026 as would be convenient to the learned courting season of the law. The order dated 8/5 रे पण पाहिजे. Because
Obliged.
yes. Yes, madam. 30. Yes, please.
On behalf of H.N. Mahapatra, Lordship, it has become innocuous. CP number 3/2016 has already been disposed of with a decree of divorce.
You have to file that memo. You are Miss Sutar, first part. Just keep. You are Miss Sutar, na? Just na Miss Sutar, na? Chinmay Sutar. Miss Chinmay Sutar on behalf of H.N. Mahapatra for the petitioner. 30 lakh. Opposite party none. ଆପଣ କୋଉ ଯାଏଁ ଯାଇଥିଲେ କି? ଆପଣ ତ 29 ଯାଏଁ ଯାଇଛନ୍ତି। ସିଧା 30 କଲ୍ କରନ୍ତୁ 30 ତାପରେ ଆପଣ ଲେଖ H.N. Mahapatra Chinmay Sutar on behalf of H.N. Mahapatra for the petitioner. Opposite party none. Learned counsel for the petitioner submits that during pendency of the application, the CP number 3 of 2016 pending before the learned judge family court Puri has been finally disposed of, granting degree of divorce.
Yes, sir.
The CP was filed by the opposite party husband. The present petitioner being the present petitioner being the respondent. Say the learned counsel files memo of date indicate which states thus. The memo shall be taken on record, scanned copy be updated. Accordingly, the petition stands disposed of. Copy of this order shall be forwarded to the learned judge family court Puri to be kept in the records of CP number 3 of 2016. Yeah. Send directly by registration. Upon Rohila Passovati mention Sutar, you give that. Sign it on behalf of H.N. Mahapatra. Yes. Yes, please.
Sir, I have 39 items.
30?
39.
39. What do you say?
Your Lordship, I am the opposite party.
Not a microphone.
We have filed
the
NOC also. And Your Lordship, we want to withdraw the objection file dated 16/12/2025.
Objection filed before this court.
Yes, Your
that cannot be withdrawn. You have to file an affidavit taking care of that. Okay. This is a court of record. Once filed,
yes, Your Lordship.
Can be withdrawn. What you can do?
Yes, Your Lordship.
Have you filed Wakalatnama?
Yes, Your Lordship, we have filed with the NOC.
You are Mr. Samir Ali.
I am Soumyaranjan Sahu. SR Sahu.
39 likhibe, Mr. Soumyaranjan Sahu, petitioner blank also. Soumyaranjan Sahu for the opposite party. The matter being listed for admission, for hearing under the heading for admission, is mentioned by the yes, Mr. Sethi. Mr. Prakash Chandra Sethi for the petitioner, Soumyaranjan Sahu for the opposite party. Mentioned by the Learned Counsel, Mr. Sahu for the opposite party.
My lord.
At the days of the.
My lord, I am not the petitioner in this case. Wrongly mentioned. My lord, I am Prakash Chandra Sethi. I am not petitioner. It has wrongly mentioned. My lord.
Wrongly, who by mentioned by whom?
My lord, somebody mentioned perhaps your lordship has a pronoun.
He appears for the opposite party. He has a right to be. He has a right to mention.
Which item? 39.
Don't get. You keep your cool, Mr. Sethi.
My lord.
You are not following the proceeding actually. No one mentioned. Rather, I dictate. But seeing you, I have recognizing you have dictated that Prakash Chandra Sethi for the petitioner, Soumyaranjan Sahu for the opposite party. Then the next part of order is. Camera. He becomes invisible. Say camera. Upon a new camera,
Shall I move that side?
So now there is some confusion. Mr. Sethi is surprised that how the matter is being taken up. He can't see you. Because of your height, actually, he can't see you.
I'm sorry. I should have remembered.
ଆପଣ ଗୋଟେ କାମ ଆପଣ ଟିକେ ବ୍ୟାକ୍ କରି ଯାଆନ୍ତୁ ସରି ପୁରା ବେଞ୍ଚ ପାଖକୁ ପଳେଇଲେ ବି ହବ yes, now you can see he mentioned the opposite party house opposite party. It is by Mr. Sahu. It is submitted that he has filed wakalatnama. The Learned Counsel appearing for the opposite party have filed wakalatnama after obtaining consent of the Learned Counsel who were appearing earlier. The wakalatnama kebe file kale?
25/5/2026.
With consent.
Yes, Your Lordship.
The wakalatnama stated to have been filed shall be tagged to the case brief. The registry shall verify the statement that consent of the Learned Counsel who were appearing earlier has been obtained and put up note accordingly. The matter shall be listed for admission in the week commencing. Mr. Sethi, 17/8, Mr. Sahu.
My lord.
10/8. Sir, we are giving the earliest date actually. 10/8 रे भी तो 108 रखछन से बात
17/8 my lord 17/8
10/8 रे आसु से जदी कहउछन
mobilize
Your Lordship,
yes please.
Your Lordship, we have the receipt of the filing of the NOC also.
It has to be filed in the registry.
Okay.
Keeping anything with you doesn't help. You have to keep the photocopy.
I've already kept
Because again, this is my court of records. They will see the document and put up a note. Do it, no difficult.
Your Lordship.
If you have not filed, there is sufficient time for you to file. ଆପଣ ତାହେଲେ ତାଙ୍କୁ ଆପଣଙ୍କର ଅଫିସ ତାକୁ ଦେଖୁନାହାନ୍ତି କି ନାଇଁ ଶୁଣନ୍ତୁ ସେଟା କେବେ ଫାଇଲ ହେଇଛି ଡେଟଟା ସାର୍ ଫାଇଲିଂ ଡେଟ୍ 25 ରେ ସାର୍ ସେ ଠିକ କହୁଛନ୍ତି 25 without taking consent from previous counsel ଆପଣ ନୋଟ ଦେଉଛନ୍ତି ଆଜ୍ଞା କଣ ଦେଖନ୍ତୁ ଆରେ ମୁଁ ବର୍ତ୍ତମାନ କଣ କରିବି ଆଜ୍ଞା ନୋଟ ତ ଆପଣ ଲେଖିବେ ଆପଣ ଅଫିସରେ କହିବେ ନା ସେଟା yes. No, it's a court need not be satisfied. There is a process.
Yes.
Court cannot do everything. Stamp reporting, documentation, verification, all those things are done by a dedicated department.
Yes.
And they are the best persons. And it is wisely so.
Yes.
Everything, if the court starts, then only one matter, two matter, the entire day will be over.
Yes. Please mention about that affidavit about objection. The order.
No, that cannot be withdrawn. Because if I record that you want to withdraw affidavit, I have to reject that prayer. Affidavit would not be, you have to think maybe out of box that how to handle it. It cannot be withdrawn.
I can file an approved application for that.
Application, or if you want a supplementary affidavit, or you can say that there are so many possibilities. Check up CPC, what are the provisions, what can be done. But as far as High Court is concerned, nothing can be withdrawn. Anything filed erroneous can lead to consequence. Mr. Ali is present. Samir Ali along with SR sir.
Obliged, sir.
The learned counsel, Mr. Sethi for the petitioner, and Mr. Samir Ali for the opposite party are present in VC. Mr. SR Sahoo, learned counsel, is present in court. Thank you, Mr. Sahoo.